The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar. You do not have to state your names. People versus James Goodson, Appellant 5 and 1, Respondent 5. People versus Ibrahim Ba, submitted. Spada versus Aspen University, Appellant 5 and 1, Respondent 5. Newport East versus Viva Floral Decorations, Appellant 5 and 2, Respondent 5. People versus Yoselin Ortega, Appellant 9 and 2, Respondent 9. Brooklyn Legal Services versus New York City Taxi and Limousine Commission, Appellant 5 and 1, Respondent 5. Ambac Assurance versus Countrywide Home, Appellant 5 and 2, Respondent 5. ED&F Man Sugar versus Gellert, Appellant 4 and 1, Respondent 4. Callahan versus the City of New York, Appellant 5 and 1, Respondent 5. People versus China Perry is submitted. Bank of New York Mellon, Appellant 7 and 3. The Respondent BlackRock Financial is 5. The Respondent, the Bank of New York Mellon, is also 5. Lewis versus Flintock Construction, the Appellant is 5 and 2. The Respondent Flintock is 5. The Respondent J&R Glassworks is 2. Cancel versus Global Fertility, Appellant 6 and 1. Respondent 6. Butler versus the City of New York. The appellant is submitted. The respondent, 2 minutes. Kupka versus Remick Holdings is submitted. Medallia Financial versus Citridis. The appellant is submitted. The case is submitted. PFJ Ltd versus Marachi is submitted. Counsel, please remember, as always, that we have your briefs, we have your records, we're fully familiar with the facts of your case, so please go directly to the most important points that you wish to make. Also, as is customary, please don't speak when a justice is speaking. This is particularly important during our virtual arguments in order to hear each other and to hear the question that's asked. And finally, please keep your mic muted until your case is called. And thank you for your patience and your cooperation. First case is People versus James Goodson.
Good afternoon, Your Honors, and may it please the court. Attorney Megan Byrne for Appellant James Goodson. According to the trial court in this case...
This is Judge Friedman. I have a question.
Sure.
As I understand your position, it's that Supreme Court Judge Marsham didn't come to a conclusion that there was probable cause for what transpired at the 28th precinct. But Judge Marsham does say in his decision, on page 9 of his decision, he says, based on the foregoing, defendant was ostensibly under arrest as he sat in the 32nd precinct holding case. The question is whether that arrest was supported by probable cause. So that arrest would seem to have been clearly supported by probable cause. I don't think you're really contending that it wasn't. Why isn't that enough to make whatever transpired as the 28th precinct permissible?
Yes, Your Honor, I believe that line you're speaking about on page 9, it seems to be a typo on the court's behalf. It seems like he meant to write, Judge Marsham meant to write 28th precinct. I think this is evidenced by the fact that when he goes on to speak about it, he only speaks about the facts as relate to the 28th precinct officers. And I think it got a little confusing because, he had to keep using these numbers interchangeably, but he only spoke about the 28th precinct officers picking Mr. Goodson up, then taking them to the 28th precinct and holding him in the cell. And I agree with you, Your Honor, that the separate arrest for the 32nd precinct, that would have been supported by probable cause. but that is not an argument that was ever made by the prosecutor in this case. So the court also before, I think on page
But
6.
if this isn't a, and I will grant you, it's certainly not, let me put it this way, it's certainly not artfully worded. But if it's not a mistake that he made, putting this in about the 32nd precinct, doesn't that sort of get the people by?
Well, I think that this court would still be held to the court's finding, because in that line, arguing that it's,
if I might
it was not a
interrupt
mistake,
you,
he says that. I'm sorry, Your Honor.
If I might interrupt you. So
Sure.
yes, it may not be an argument that the people made. Let's say it wasn't. Let's grant you that. But if Supreme Court reaches decision based on that, that would nevertheless provide a basis for an affirmance, would it not?
It wouldn't in this case only because the court did not go on to say that there was any probable cause for this arrest. So the court explicitly found there was no probable cause.
Counsel, I'm sorry, this is Judge Singh.
Sure.
Does the court have to use those precise magic words? Wouldn't it be sufficient, for example, for the court to say that it was appropriate for the police to detain defendant in order to arrange a lineup for viewing? Isn't that what the court is really saying, is that there was probable cause? Isn't that really what's happening in that statement?
I don't think it was, because right before the court said that it was appropriate, in the paragraph right before, the court says, in the absence of probable cause, this court must consider whether the actions of the police violated his constitutional rights, on page 10. And then on page 11, the court concludes with the line, probable cause to arrest followed his confirmed identification at the lineup. So the court, again, the decision can be kind of, I think, harder to read through, but the court is clear, I think, by saying in the absence of probable cause, this is what the court is looking at. Certainly by ending with probable cause follows the confirmed ID at the lineup, says that's when probable cause entered the case in the court's opinion. So the court does make an explicit finding as to probable cause in the decision. And so given that finding that this is the probable cause arises after the lineup, of course, the question becomes, is being held prior to the lineup in the 28th precinct supported, or is that a violation of Mr. Goodson's constitutional rights? The reason the court believes that it isn't is because, and the court makes this clear by citing to, I think, People v. Hicks and People v. Shaw, the court cites to cases in which people have been held for lineups only on reasonable suspicion without probable cause in order to effectuate the lineup. However, in those cases, it's just for a matter of minutes. It's not behind a cell. It's very different from this case.
So what's the remedy here? Are you suggesting we hold the appeal in abeyance and remand for the court to make whatever findings it's going to make, or what?
Well, no. Our position is that the court has already made its two findings that it needs to make for this to be a new trial.
But it hasn't made a finding. I'm sorry, but has the court, based on your argument, made a finding with respect to probable cause?
The court made a finding, yes.
It did make a finding with respect to probable cause?
Yes.
Okay.
Yes, by saying that, by stating that there was an absence of probable cause, I think that's a finding of there's no probable cause. And then by saying probable cause, or the probable cause to arrest followed his confirmed identification at the lineup on page 11, I think that's an explicit finding also that this is when probable cause did come in on this case. If there was error here,
this is Judge Friedman again, if there was error here, is this subject to harmless error analysis?
Well, I mean, if it were, this is certainly not a harmless error in this case, because of the statement that was made during those several hours that Mr. Goodson was held before the lineup happened. So that statement that I'm talking about is he made multiple statements, but he also said he didn't sign the barring notice, so it's not legal. And this is one of the shoplifting cases where usually the prosecution's case is made by showing a barring notice, usually signed by the defendant. Here, the barring notice, there was no barring notice that was actually allowed into evidence. So this is kind of a unique case in that way, because it wasn't signed by Mr. Goodson. It seemed to be signed by someone else, some other name. And of course, the whole issue in this case is, did Mr. Goodson know that because of something that happened in 2016, he couldn't enter the store in 2018, making that a burglary?
Well, the barring notice, he's not able to identify the signatures on it, but doesn't his testimony support that the barring notice was given to the defendant?
Well, the only thing that would support that is if the statement is came in while he was incorrectly under custody for hours before the ID. Only him saying, I didn't sign it, so it's not legal.
Doesn't Mr. Gordon himself, absent a statement, support that the barring notice was given to the defendant?
He does say it was given to Mr. Goodson and that he signed it. The barring notice doesn't seem to show that. And I think what's significant about Mr. Gordon's testimony is that he's really testifying off of what he does in these cases. And he says that clearly to the court, that he says pretty much the same thing to everybody. And the court asks him, are you relying on a specific memory of what you told the defendant, or are you relying on what you generally told people? And he said, what I generally tell. So I think that where you have a case where there is no signed barring notice, the person who said that he issued the barring notice doesn't have a specific memory of telling Mr. Goodson anything in particular. The fact that Mr. Goodson says, well, I didn't sign it, so, they can't get me for it kind of thing, makes it particularly harmful in Mr. Goodson's case.
Thank you. Let's hear from the respondent.
Thank you. May it please the court, Philip Tisney for the respondent. The first thing I want to respond to is the suggestion that the whole issue in this case was whether defendant knew he was barred from the store. Not only was that not the whole issue, it was conceded twice that the defendant knew that he was not allowed back in the store. In defense counsel's opening and again in his summation, defense counsel conceded that the entry into the store was knowingly unlawful, because he said you should convict my guy of trespass, but don't convict him of burglary. So to say that now the whole issue
because the defendant had wrapped the items taken. Don't convict him of burglary because the defendant really didn't take the items.
No, I think the defense counsel's strategy at trial was burglary doesn't exist here because you can't show my client's intent to commit a crime inside. The theory in the summation was that the video surveillance testimony was equivocal about what happened when he tried to leave. Obviously the prosecutor said, depicted that the surveillance video as showing the defendant struggling and trying to get away. Defense counsel's position was this isn't a struggle that was initiated by the defendant. This was a struggle that was initiated by the store employee. And really, my guy was just trying to fight back. So it doesn't show an intent to flee. Their main argument was about intent. And that's why both in the opening and the closing, defense counsel says, listen, trespass, you could find my client guilty of trespass, but you can't convict him of burglary. And that's important, of course, because the main element of a trespass conviction is a knowing unlawful entry. So to say now that the main issue at trial was, a contested issue about whether the entry into the store was knowingly unlawful is just, it's just not supported on the record.
But let's turn to the probable cause issue. I mean, I think at some point there's a suggestion that we find LaFontaine is unconstitutional, which I don't see how that suggestion can be made. The appellate division can't find a court of appeals holding is unconstitutional. The Judge Martian seems not to get past reasonable suspicion for the defendant having been held for at least 5 hours for this lineup. So there was an easy way to approach this case. There was probable cause for the arrest that landed the defendant at the 32nd precinct. He's still properly in custody in that point. You bring him to the 28th precinct. They don't need to establish a new probable cause for that. They have the probable cause of the original arrest, and then they can hold him for the lineup. But it's not the way the case was approached. So how do you get past the issues that the way this was handled at Supreme Court in terms of establishing probable cause?
Well, a couple of things that I disagree with there, Judge, and respectfully. First, we're not asking you to overrule LaFontaine. We take as a given LaFontaine's construction of 470-15. We're only asking this court to consider whether, as so construed authoritatively by the Court of Appeals, whether it violates the Constitution. Putting that to the side, I also disagree with the characterization that this wasn't the way the case was presented. The parties went through their arguments, the suppression hearing, focusing on whether there was additional probable cause for the March crime. But in the middle of her presentation, the prosecutor stopped and said, listen, we don't need additional probable cause for the March crime because the defendant was already lawfully in custody for the April crime. So it's irrelevant whether the other stuff that happened gave the police probable cause for the March crime. Now, in any event, she continued, we had probable cause
so
for the March crime.
that was the point I was trying to make. And the sentence, the line in the decision below, which supports what you're saying, is, which your adversary says is a typographical error. Based on the foregoing, defendant was ostensibly under arrest as he sat in the 32nd precinct holding cell. The question is whether that arrest was supported by probable cause, and there doesn't seem to be much of a serious issue, but that it was. That's me speaking the last thing. So that's is some support for what you're trying to say, but your adversary says that's a typo.
Well, in fairness to my adversary, there are several places in the decision where there are typos where the judge has transposed the 28th and the 32nd precinct. I'm not sure whether that's one of them. I can't get in Judge Mershon's head and know what he meant in that particular situation. But I will say that the decision only makes sense if it's understood as having adopted the idea that a defendant was already lawfully in custody for the April crime, and it was reasonable for the police to hold him for the lineup on the.
So
April,
that's the point,
March.
counsel, I was trying to make. So how do you reconcile what the judge actually says and what you're saying now?
Well, so the judge starts off his analysis clearly saying, listen, when the defendant landed at the precinct, and regardless of whether it's the 28th or the 32nd, when he lands at the precinct, the seizure of the defendant is such that it constitutes an arrest requiring probable cause. The judge says this. He said the question in this case is whether there's probable cause. Now, that's when he lands at the precinct. Judge then says there isn't probable cause with respect to the March crime until after the lineup. Nevertheless, the judge decides that suppression should be denied. So there's a gap in time there where the judge recognizes that there needs to be probable cause. The only other probable cause that existed was the probable cause, the indisputed probable cause with respect to the April crime. Now, at the hearing, even defense counsel conceded that, of course, there's probable cause with respect to the April crime, and the judge noted that concession. It said, listen, nobody is challenging whether there's probable cause with respect to the April crime. So Judge Friedman, I think your point is exactly right. The judge knew in the back of his head, although he didn't say explicitly in the decision, in the back of his head, he knew this defendant, the police already have probable cause to hold him. The only question then is whether, under Whitaker and Jackson, in the cases that we cite, the appellate division cases that we cite, the only question is whether it's reasonable for the police officers to hold him in the station to do the lineup for the March crime. And that's where I think you get this language where he's talking about the police at least had reasonable suspicion. I think that's best understood as the judge saying, well, it was reasonable for the police to hold him to do this additional investigation because, frankly, if you look at that language and consider whether the court was doing a sort of a straight probable cause analysis, it wouldn't make sense for the judge to say that, well, the police had at least reasonable suspicion. The judge had already said, I have to determine whether they have probable cause. So saying that they have at least reasonable suspicion is sort of neither here nor there. The only way that comment makes sense is if he's trying to articulate a way in which it's reasonable for the police to continue to hold this defendant while they're investigating the other crime. And he says, listen, it's reasonable for them to do that. It's appropriate for them to do that because the information they had at the time gave them at least reasonable suspicion to do that. That's why we think. Counsel,
this is Judge Singh. What's your position with respect to a remand? I'm hearing your arguments, but what do you believe that we could remand, or there's no need to remand based on the arguments you're making?
So there's two reasons why a remittal isn't required. First, it's not required because regardless of what you decide about what Judge Mershon's decision says, you can reach the preserved alternative ground that the prosecutor argued below, the one that we've been talking about, regardless of 470.15, because, as we say, that section is unconstitutional. There's no need to send this case back down for the hearing court to address an argument that it didn't address, although it was preserved, and then to bounce it back here. It's just a waste of time. Everybody recognizes that's a waste of time. Even if you don't like that idea, there's no need to send it back for a remittal because of harmless error. For reasons that I outlined at the beginning of my argument, the admission of these statements would not have affected the outcome, the jury outcome in this case, because the only aspect of the crime that those statements were relevant to were sort of marginally to his identity and to his knowledge, and those issues were either not disputed or were affirmatively conceded in the trial below. So to suggest that it would have made a difference on these undisputed or conceded issues to keep out one piece of evidence, which was, I'll add, only a tangential piece of evidence that the people relied on only after they had sort of articulated the rest of the evidence supporting each of these points. To say that that would have made a difference in this case, I think is
there's something I want to be sure I'm understanding correctly. The benefit card is recovered at the scene of the March crime, right?
Yes.
And that's introduced in evidence, is it not? Or
the benefit card is introduced into evidence, although that's not what is they're trying to suppress. They're trying to suppress his statement.
I know that. But in terms of harmless error, in terms of the strength of the case against the defendant, he drops a benefit card, which is a picture of him.
Yeah.
At the scene. You mentioned it's tangentially relevant identity, but in terms of identity, there's evidence that he dropped that benefit card, which has his picture on it.
Which is not subject to suppression. Exactly. The only way the people use the statements with respect to identity is after talking about all of that evidence, they say, oh, and by the way, when he was in custody, he said, I didn't sign it, so it can't be legal. So he must have been the guy who committed the March crime because, look, he knew about it and he was making comments about it. But the prosecutor only said that after she had detailed all of the other evidence in the case, including Gordon's testimony, including the ID, including the lineup, all of this other evidence supporting identity. And she even said, listen, identity is not something that the defendant is contesting. I still have to prove it to you, obviously, beyond a reasonable doubt, but there's no dispute here about it. So here's my evidence. It's the same thing with the knowing unlawful entry.
Thanks.
Okay.
Okay, thank you. Let's hear from Ms. Byrne.
Yeah, so on the issue, Your Honor, about the typo, I think just an aside, something else that supports that is that at the bottom of page 10, Judge Marchand again says, this court found that at the time the detectives of the 32nd precinct picked up defendant, they had reasonable suspicion. He means, I think, again, there, the 28th precinct.
Counsel, did anyone try to, you're saying that it could have been a typo, did anyone try to seek clarification from Judge Marchand about that, if it was a possible typo? I mean, you're arguing it now, but I mean, there's plenty of opportunity to do that at the court below, right?
I think, yeah, counsel could have, but no, there's no discussion that I know of about this typo.
Counsel, this is Judge Singh. Going back to your adversary's point that defense counsel at trial essentially was conceding a trespass. If that's the case, how does that doesn't harmless error analysis come into this issue?
Well, I think that what's significant here is one that at the mission to dismiss stage, defense counsel and even the trial court at the time asked the prosecutor, what is the evidence here that Mr. Goodson wasn't allowed to enter? Because that really was the issue. It wasn't identity. It wasn't an identity case.
But in summations, did defense counsel take the position that your adversary is saying was taken with respect to the trespass, but not the burglary?
It seemed to me that he did take that position. It seemed to me that this was very much a kind of trial strategy.
Wait a minute, second. If that was a strategic position you took, understand why that position was taken. Wouldn't harmless error analysis sort of play into it, and then we don't have to get caught up on the issue of what the judge really meant and the decision and typos and et cetera?
It could have been, but it really seemed that he was trying, kind of arguing the alternative, both this trespass argument that counsel is talking about, as well as that he wasn't notified because of the barring notice, because the barring notice in this case didn't even come in. And I think also,
but the barring notice is evidence, right? It didn't come in, but testimony is evidence too, which the jury heard, and it seems to me that would be sufficient, no?
Well, the barring notice, the testimony about it was that it seemed that it was signed by someone else, but yeah, that the jury would have heard that. The argument here is that that would have made it this would have been a harmless error, or sorry, not a harmless error, because the prosecutor then, in her summation, then said twice, you heard his statement. He said that, he saw the barring notice, but he didn't sign it. Why would the prosecutor use that twice if this statement really means nothing to their case? I mean, I think that goes to the fact that it is really affecting the case here, and that it was something that did prejudice, Mr. Goodson.
Thank you.
Thank you, Your Honors.
Thank you both. People versus Spada versus Aspen University.
Yes, Your Honor. Judah Scoff on behalf of the appellant from Greenbaum, Rowe, Smith, and Davis. May I proceed?
Yes, please.
Okay, Your Honor, and may it please the court. There are two principal issues before the court in this case that are separate but make up the lawsuit as a whole. The first question is that of statute of limitations in connection with the claims for breach of contract and unjust enrichment in connection with $50,000 that the appellant provided to the respondent, Aspen University. The second is whether or not the documentary evidence submitted by the respondent is sufficient to foreclose Mr. Spada's claim for declaratory relief, seeking that to be determined the shareholder of Aspen.
So, counsel, the 6-year statute of limitations is what would apply here, but that was missed, right? To begin.
No, Your Honor, it was not missed, Your Honor. The note is not a promissory note. It's not a demand note. It's a convertible note. And the rights which accrue to Mr. Spada under that note are not time-bound at all.
That's because you believe that Mr. Spada had the right to sort of state when this the default occurred.
Well, the note gives him that opportunity because the note does not put any time limitation whatsoever on when it is that he can make his election.
But under our traditional understanding, doesn't the accrual occur when there was first a wrong? And in this case, the wrong would have occurred when the note came due.
Your Honor, that is the traditional understanding. That does not apply here because to apply that standard, as Supreme Court did, would effectively deny Mr. Spada his conversion rights and his ability to make an election of remedies under the convertible note. The respondent described it as a promissory note. It is not a promissory note. It functioned like a long-term option contract, which is why under the terms of the note, Mr. Spada has the right to declare a default and not seek repayment. That's written in the note itself. And the reason for that is because it preserves his conversion rights, which are not time-bound. And so effectively, Supreme Court read the obligations which apply only to respondent, the maturity date, the repayment obligations, that only applies to respondent. It is not a reciprocal obligation on Mr. Spada to seek sums due. That's why it gives him the opportunity to declare a default. It gives him the opportunity to declare a default without seeking repayment, and it does not put a time frame on his conversion rights. The only thing that the maturity date in the note does is it forecloses the respondent's ability to repay the loan before Mr. Spada has the option of deciding whether or not to seek repayment or whether or not to seek
conversion. Counsel, isn't doing that sort of changing the statute of limitations? Isn't that changing the time? I mean, you're essentially saying the 6-year doesn't apply to me, and I can extend it until I begin my client declares the default. Isn't that
I don't think it does. I don't think it does, Your Honor, because I think the statute of limitation begins to run once Mr. Spada makes his election. In other words,
whenever makes the election, he makes an election 20 years from now, there's no issue with the statute. Is that your point?
I mean, theoretically, that could be the case, Your Honor. I mean, that's not what ultimately happened. But as I noted,
but is there a case out there that supports the position that, in effect, the statute of limitations will never run in this kind of scenario because you have an election of remedies?
I didn't find an exact case which said that, but the fact of the matter is there is no time frame. I mean, this is, I think, the key point about the note.
Why isn't the point that you have a right to convert? The note gives you the right to convert. But that doesn't affect that the due date was March 1st, 2014. Till March 1st, 2014, yes, you could have done whatever you wanted. But if that date comes and goes, that's the maturity date.
That's the maturity date, but the only thing that the note says is that the respondent has to repay by that date. There is no reciprocal.
What else does it need to say to make that the cutoff date?
Justice Friedman, there is no reciprocal item in the note which says that Mr. Spada must make his election by that date. There's nothing in the note that restricts his rights in that fashion at all. The conversion rights are open-ended. They are not time restricted. This was an investment in Aspen University. It was an early stage company. It was not known how long it might be in existence. It was not known how successful it may have become, or when Mr. Spada may want to make his election. His rights are not time bound. There's nothing in the note that says he has to make his election by the maturity date. It's not in there. And that's why the relevance period is when he makes his election, and in this case he did seek repayment, and he effectively made the election, and he filed his lawsuit within the.
But according to what you're telling us, there's never a statute of limitations on this note because he's always got a right to convert.
Your Honor, no. The statute of limitations would be 6 years after he made the election. That's
Which he could make at any time.
Correct. That's correct, Your Honor.
So it would never run because he always could still make it.
Well, he made it though, Your Honor. So he made the election in September of 2015, and he filed the lawsuit within the 6-year period of making the election. So that ultimately didn't happen.
Aren't you what you're saying? If you're saying that what you get to do pushes back the statute of limitations, aren't you really saying that that's a condition precedent to your being able to make the file the action?
If in the sense, I'm not sure I completely understand the question. If in the sense that he has to make his election and seek repayment before filing a lawsuit, then the answer is absolutely yes. And he did that. He sent them a notice of default and demanded repayment.
But tell me, counsel, wouldn't your argument be stronger if in fact your election was not repayment? Because it seems to me that you're doing an end run of the statute of limitations. Maybe if you chose a different remedy, you could make that argument. But with respect to the maturity date is clear. Why shouldn't we just look to the maturity date under these circumstances, especially since your election is repayment?
Well, because, Your Honor, if I'm understanding Your Honor correctly, it's like if he decides to convert, then that's open-ended. But if he doesn't decide to convert and seeks repayment, that's tied to the maturity.
Because the conversion rights arguably are open-ended, right? But the maturity date is not. There is a date certain upon which the note matures.
And if you look at the provision, Your Honor, about the maturity date, all of the language in the note applies only to the respondent and the respondent's obligations. There are no reciprocal obligations upon Mr. Spada at all anywhere in the note. There is nothing in the note which says upon the maturity date he has to make the election, or on the maturity date he has to declare a default. Nothing. It is not in there.
But the issue is what's the legal effect of the maturity date? Is the accrual for statute of limitations purpose that date? I mean, that's what we're discussing.
Your Honor, I
don't know if that needs to be in there for us to make that finding.
Your Honor, we would argue that it is not the appropriate date for statute of limitations purposes, because the effect of the maturity date, prior to the maturity date, the respondent had the ability to unilaterally determine to repay the note and foreclose Mr. Spada's conversion rights. They had that ability to do so prior to the maturity date. After the maturity date, they no longer have that option because they didn't repay it within the maturity date. After the maturity date, Mr. Spada has the sole power under the note to determine whether or not to seek repayment or conversion. And if you think about this as an early stage company, it makes a certain amount of sense, that if the company, was going in a particular direction, maybe doing well, maybe not doing well, whatever, they could repay the note prior to the maturity date. But if it went on longer, then Mr. Spada is rewarded for his early investment, and then he has the ability to make a determination as to whether or not to seek repayment or whether or not to seek conversion. I'll mention briefly if the court would like to hear it, about the second issue, which is the declaratory relief. Mr. Spada has filed.
Your time is up. Why don't you finish that on rebuttal? You have some rebuttal time.
Okay, Your Honor. Thank you, Your Honor.
Thank you.
May it please the court, Stephen Shore, Gam for Shore Leeds, etc. Your Honors, I just want to read their allegations in the amended complaint because they belie the current argument. The paragraph 7 reads, pursuant to the terms of the note, 2 years after execution or sooner, defendant was required to pay plaintiff the sum of $50,000 plus interest. That's paragraph 7. Paragraph 8 says, defendant failed to pay plaintiff $50,000 plus interest at the end of the 2-year term. So their pleadings allege that they had an absolute right to this money on March 30, I think it's March 31st. And they didn't bring a claim within 6 years of that date. And this court has repeatedly followed on. There's a decision by Justices Friedman and Mazzarelli from 2020, New York Environmental Analytics, which reiterates the long-standing rule that when there was a right, that's the date that starts it. And here, their own pleadings say they had the right and the money wasn't paid. And then this other argument that they now make about the options is irrelevant. It has nothing to do with this because they had a right, they didn't exercise it, and they didn't get paid.
Well, was that, Mr. Shore, was that an open-ended right? The conversion rights were open-ended? Is that correct?
No, I don't believe the conversion rights were open-ended. I think the maturity date in the first part of the note where it says it expires in 2 years, and it has the additional language, if not paid or converted sooner, I think that makes clear that that's also within the 2 years. But the argument is irrelevant because paragraph 9 of the amended pleading reads that they never elected to seek the common stock. So they've indicated they didn't make that election. They've indicated that the note was a 2-year note, that the note came due and it wasn't paid. And I think that's the end of the discussion under Hahn and the New York Environmental and Sotheby's that Justice Friedman, you wrote on. I think the case law is very clear. Their own allegations, paragraphs 7, 8, and 9, doom the argument.
Sotheby's certainly supports the proposition you can't just fiddle with the statute of limitations like this.
I'm sorry.
You can't just adjust this statute of limitations. That there's a public policy interest in the statute of limitations running from a date certain.
Correct, and the case law that you've all written on makes clear that when that right came into existence, and it came into existence, their own pleadings say it, and that's the date that you go from. If you, with respect to the unjust enrichment, this court has repeatedly held that when you have a contract claim, there's no unjust enrichment claim. The cases that they cite, don't contravene that. I think one of them indicated that it was a second department case. There's no first department cases they cite, no court of appeals cases they cite.
So let me turn your attention to the other issue, which your colleague will address in reply, about whether they're entitled to additional shares. On page 24 of the record, there's a letter from Aspen. Dear Aspen University shareholder, please find enclosed a common stock certificate, the dividend, for the additional shares you are receiving as a dividend. So there's references as to shares, and of course it's the appellant's position that there wasn't just this one 450,000 group of shares, but they're entitled to other shares also. How do you explain this plural, the reference to additional shares, the use of a plural, which does that not support his position that he is entitled to more than, that he was entitled to more than just the 450,000 shares?
No, Your Honor. If you take a look at the documents, and indeed, I think it's paragraph 2 of the note, it talks about the fact that they expected there to be a reverse mortgage with a public company. This was Aspen University. There was going to be a merger with Aspen Group. And their own documents referred to the fact that they anticipated it was going to be a stock split. There was additional stock back in 2011. But what happened was there was a reverse stock split. You can look at the record in the bankruptcy court decision. It talks about it at record 80. And what then happened was they received in May of 2012, they received, look at the stock certificate, it's from Aspen Group. That's now the stock certificate they had. That's the stock that they possessed. And if that was wrong, if they had an argument that they should have gotten more shares, then they should have gone to the transfer agent back in 2012 when that certificate was issued, but they didn't. So yes, you have a certificate going back to May 2012 of Group, and the documentary evidence shows that their brokerage firm asked for the certificates. It was sent to them, and it was put into street name. And the complaint, as opposed to their brief, say, yes, there's additional shares. We're not disputing there was additional shares, because if you look at the bankruptcy court papers, the bankruptcy court determined to dispute between an affiliate company and Mr. Spada, and said that you get 69,000 shares. And there's no dispute that he then got those 69,000 shares. Now,
did you finish your thought there before I?
I think if I've answered the question, then I've stopped.
I think so. On to Mr. Scoff. Thank you.
Yes, thank you, Your Honor. So with respect to the declaratory relief claim, as Justice Friedman referenced, there is the July 7th, 2011 letter, which references the additional shares, meaning that as of that date, Mr. Spada was presumably already a shareholder. And the documentary evidence submitted does not in any way deal with that question. And nor does, as counsel referenced here, and as they put in their papers, the suggestion that those 2011 shares in University were converted to the 2012 shares in Group. There's nothing to demonstrate that. There is no, that is a statement made by Mr. Matthews in his affidavit. And we've put in some cases that unsupported statements and affidavits are not sufficient to foreclose a claim on documentary evidence on a motion to dismiss.
Counsel, how about with respect to the 450,000 shares?
I'm sorry, Your Honor?
How about with respect to the other tranche of shares, the 450,000 shares? What's your position with respect to that? Why doesn't the documentary evidence utterly refute your claim to these? Because you asked them to be transferred to a street name, and presumably you have a remedy to go to the brokerage company holding those shares.
The transfer took place with respect to the 2012 shares, not with respect to the 2011 shares. It's the 2011 shares that we're basing our claim on, and our client's position is that.
I'm sorry. So with respect to the 450,000 shares, what's your position with respect to that?
With respect to the 2011 shares, our client's position is that he still holds them and that he should be recognized as a shareholder today. And in addition, that he has should have the opportunity to determine what Mr. Matthews was referring to when he made reference to the additional.
So which shares were put into street name?
The 2012 shares. The 2012 shares in Group. Not the 2011 share. Mr. Shore stated just now, and also they argued in their papers that those 2011 shares.
What supports interpreting the record that way, that it relates to the 2011 shares and not the 2012 or vice versa?
Your Honor, our argument is there's nothing in the record that supports that contention. That's the basis of the claim. Is that Mr. Spada continues to hold those shares, those 2011 shares. And also the additional.
But there is evidence that you asked for shares to be put into street name.
No question, Your Honor. That's not the basis of the claim, and that's not.
And I want to be clear, that's the 2012 shares that
Correct.
were put in the street name?
That's correct, Your Honor.
Thank you.
And that they did put material in, but the basis of the claim is the 2011 shares and the reference to the additional shares. And it was Mr. Matthews, of course, who submitted the affidavit on behalf of the respondent. And if he had been able to clear this up, presumably he would have cleared it up. But he made no reference to the.
Well, but an affidavit, this is a motion to dismiss, 3211A1. We normally don't consider affidavits, right? It's really what the documentary evidence is. Right?
Well, Your Honor, that's sort of precisely the point, which is that the statement in the affidavit that the 2011 shares were converted to the 2012 shares in group is not backed up by any documentation. Mr. Shore made reference to something about a reverse mortgage. These are factual issues which need to be dealt with in discovery and before the court. They're not appropriate for a motion to dismiss. There's certainly not documentary evidence to that effect.
Thank you. Thank you both.
Thank you, Your Honor. Thanks to the court.
Thank you, Your Honor.
Newport East versus Zviba Floral Decorations.
Yes, good afternoon, Your Honors. I'm trying to get my camera on.
If you can't get it on, just begin with, audio.
Okay. So thank you. I apologize about that. May it please the court, my name is Alan Bushlow. I'm an attorney with Abbott, Bushlow, and Schechner, and it's my pleasure to argue this afternoon on behalf of the appellants in this case. At the trial court level, the trial judge determined that what was bought and sold in this case was not goods. There I am. That was clearly legal error. My clients sold to the plaintiff in this case a floral centerpiece. It was designed at their specific request to fit on a 7-foot wide.
So in other words,
table.
counsel, your argument is that your a bunch of pieces were sold and they were put on a table and they magically turned into a piece of art. Isn't this really a claim for services? The services are the artistic services of your clients?
No, that's not the case at all, Your Honor. It was a centerpiece. It was one big giant centerpiece, but it was a centerpiece. Just like when you.
But counsel, isn't this kind of, sorry to interrupt you, but counsel, isn't this, it's a mixed kind of a production here where it was the items, but the items were nothing, I think is what my colleague is suggesting. The items were nothing if they weren't designed and put into this floral piece. Otherwise, they were just, stems of silk flowers. So it seems like the greater of the two, whether it was goods or services, it seems like the services aspect of this predominates. In this creation, you would call it a creation, wouldn't you? They created something?
No, they sold a centerpiece. It was a very big centerpiece.
They had to go there to put this thing together, right? I'm sorry, Judge Pitt.
Well, my question was, it was a designed centerpiece. In fact, there were sketches submitted for approval as to the design, right? It's not as if they purchased it.
That's actually a disputed fact whether the one sketch that's in the record was intended to represent the final product. But, every good that's sold is made of components. You could take a fine meal by a Michelin 5-star chef, and each dish that he serves the patrons is goods under the UCC. There's no discrepancy about that. And yet, only that 5-star chef can take each of the ingredients, put them in the pan, turn them into the meal, and then deliver them to the table.
So the question is, do the services provided by that 5-star chef turn that into something different than merely goods?
And the answer is no. We know that people, when there have been cases when people go to restaurants and get sick, they allege breach of fitness claims under the UCC. When people buy a car, They allege UCC claims for breach of warranty if the car
But
malfunctions.
what are the services provided for the sale of a car? It's not as if your clients designed the car and created the car and brought it to the defendants, right? I mean, in this case, they
yes, Your
acquired
Honor.
the pieces, no, and designed
Actually, yes.
them.
I'm sorry, Your Honor, but
I just
actually,
said the
yes.
pieces.
When you sell a car, that's exactly what happens. General Motors designs the car, they test the car, and then it's delivered to the purchaser. But the fact that it's made up of component parts, and by the way, in today's day and age, the car isn't even, all of the parts aren't even made necessarily by the manufacturer. They're getting them from different
Counsel, may I ask something? I'm sorry, Justice Mazzarelli, why don't you go ahead?
Yes, I wanted to ask counsel, is it not true that a piece of filet mignon in the hands of a five-star chef ends up as a very different thing than a piece of filet mignon in the hands of a short order cook?
Absolutely, but they're both goods under the UCC, Your Honor.
Not the finished product. The finished product by the five-star chef goes for one price, and the finished product by the short order cook goes for another price.
They go for different prices, but they're both goods under the UCC, Your Honor. And the fact that something is a work of art, or that something is priceless in the figurative sense.
This is Judge Friedman. I don't think.
I would think your clients would find it somewhat insulting that you're saying that the item that they delivered was not a work of art, was not a piece of something that they had created as part of their skill and their artistic development. I mean, they had to install this. This was a display made, as they said, out of their creativity and vision.
Your Honor, I would refer the court to the Beard case, which we cite in our brief, where literally fine works of art sold by art houses and galleries are goods under the UCC. And
well, I don't think
it's different
Counsel,
from
this
that,
is
right?
Judge Friedman. I don't think the car analogy serves your interest. There are a million Chevrolets produced, all of which are more or less the same. This was supposed to be a one and only unique work of art.
I would argue, Your Honor, that a handmade Rolls Royce is also goods under the UCC. One of a kind handmade Rolls Royce. It's goods under the UCC. There's nothing pejorative about being governed by the UCC. It's a battle-tested statute that is meant to apply in most commerce situations. The exceptions to when it applies are much narrower than when it does. Services, construction contracts, things that are not tangible, and things that aren't movable.
So let me ask you this question, counsel. Moving on from that, the rejection, if it is goods, the rejection of those goods, right? They put together this design. They did the board did not appreciate. They did not like the design. They did not think it's what they bargained for, and they told them to come and take it away. They rejected it, right?
Actually, that's not factually accurate, Your Honor. There's no allegation in the complaint, let alone in any of the papers submitted on the motion, who it was that rejected this. The only record evidence is from my client that the people that were designated by the board to work on this project all approved of it and called it beautiful and a work of art.
So they just told them to ask them to take it away.
Well, but the point is rejection. Yes, they rejected it, but they didn't give us a basis for the rejection. You can't go
Am I correct? This is a motion to dismiss the complaint, and what we should be examining is the adequacy of the allegations, not the ultimate liability on one or the other?
Yes, Your Honor, but on a motion to dismiss, the court can determine whether the plaintiff has a claim, not just whether they state one. And in this case, they haven't even alleged, other than saying they thought it was ugly, which gives the vendor absolutely no opportunity to cure it. We don't know what it was about it that they did.
Okay, you're also moving. I want to turn your attention to another aspect of your appeal. You're also asking for the case to be dismissed against Barry individually and to be dismissed against the corporation. Isn't there enough to keep Barry in because his cell number is listed on the invoice, the payment is mailed to him, he comes down to help install the project. the nature of the team that's doing the job. Isn't that enough for pleading purposes to leave Barry in individually? And since there is a corporate name which is listed and is still active on the website, doesn't all of that make them appropriate, at least in terms of a 3211 motion, to remain in the case?
Actually, Your Honor, my client would like nothing better than for the corporation to have been the responsible party. Unfortunately, I had to deal with the facts we had. Had it been a corporation, I think it would have been an open and shut case that the employees of the corporation are not liable for the acts of the corporation. The analysis, however, is still the same, even when you have a sole proprietorship. Every document in the record and every piece of testimony by affidavit suggests that the only vendor in this case was Catherine Sviba doing business as a sole proprietor as C. Sviba. In fact, the ironic thing is one of the arguments in this case is that they want a refund of what they paid. They paid C. Sviba. So they can't possibly argue that Barry Carlin was—
And mailed a check to Barry.
No, they mailed it to C. Sviba. They're a married couple. They mailed it to her home.
But
and she deposited
it. Isn't the address provided for the payment to be mailed, says mail it to Barry at that address?
I don't think that changes the analysis, Your Honor. And in fact, C. Sviba did an affidavit, and she said she's the one who deposited it.
And as to the corporation, you say the corporation no longer exists.
No, we don't say that. We say it technically exists on paper, but it hasn't been used in many, many, many years. It has
so what's the point of having it on the website if it's not being used? Every time someone sees it on a website, it seems to me it's being displayed and being used.
First of all, Your Honor, the website arguably is outside the record in the sense that the only person that authenticated that was the attorney, and it's dated after the events at issue in this case. But the other thing which jumped out at me when I looked at the website, it doesn't say Inc. anywhere. Nowhere.
Yeah, but counsel, I'm sorry to interrupt you, but you saying that the website is outside of the record, but the it was also on the proposal and the invoice, wasn't it? And then the website was on the proposal and it was on the invoice, and that explicitly referenced SFD.
But it doesn't say Inc. It's Sviba, her name, Floral Decorators, but she hasn't used it for years.
Okay.
But believe us,
counsel, we're going to move on to your opposing counsel. Okay, I've given you a lot of extra time.
Thank you.
Good afternoon, Your Honors. May it please the court. Malad Baduhi from Schwartz-Slakis, Reich Grimberg Atlas.
I know, Judge Freeman, I know it's not the main point, but since we finished up with that, I believe that counsel is right that it doesn't say Inc. on the for the name, which we say is a corporation. What's the significance if it's not saying Inc.?
It also doesn't say C. Sviba. It says Sviba Floral Decorators, which is which just missing the Inc. I don't think is enough. It's the website that they've been using. It says that they've been in business for 25 years. I don't think the Inc. makes you think it's C. Sviba, meaning Catherine Sviba personally, and not the entity. I think at best it's very confusing. I don't think even appellants knew who was involved here. That's why appellants sent a demand letter saying we represent Sviba Floral Decorators, Catherine and Barry, and that's what their demand letter said, that they represented all three. And that was before the lawsuit was filed. So I don't think the Inc. helps them here. And at best, it's an issue of fact. So, and jumping right into the UCC point, I know that we've talked about this and I don't want to, beat a dead horse here, but this is much, much closer to interior design services, which this court in Hagman versus Swenson already ruled is predominantly service oriented and not a good. They're not just putting paint on a canvas or putting widgets together and selling them, or a car that's being mass produced and mass sold to many different people. They are coming into a space. They're floral designers, and they're designing something to fit in that space. Much like an interior designer takes bits and pieces of goods. They take furniture, seats, paintings, lamps, and they put them all together to create a cohesive scheme that fits within a room. It's the exact same thing here. And if it's not exactly the same, it's very, very, very similar and way far on the spectrum, far away from a widget, taking us all back to law school for a minute. So I'll move on. And on the rejection point, I think it was counsel in their brief where they admitted that they were rejected, that the floral arrangements were rejected. If they weren't rejected immediately, then they were rejected when I wrote a letter to counsel telling them exactly what was wrong just a few weeks later, letting them know what was wrong, attaching a picture and the picture and the drawing itself, and letting them know that these two things don't jive with one another, and explaining exactly what was wrong. So they were rejected, and their response was, "We gave you what you asked for." They didn't say, let us come and cure. They said, "We gave you what you asked for, sorry." So even if the UCC, whether the UCC applies or not, it doesn't matter. On the SFD and Barry point, the entity versus Barry being involved, again, in their own letter to us before the lawsuit was filed, they said they represented all.
Is that in the record, counsel?
That is in the record, Your Honor, yes. I can point you to it if you like.
Oh, that's fine.
Okay. They said that they represented all three. I think they were confused even as to who this contract was with. Their husband and wife, they live at the same address. The entities in the. Are
you suggesting that a husband can't be an employee of the wife? Is that what you're saying?
No, I am not. I'm careful not to say that. But in a news article, Barry is quoted as saying, "I'm a co-owner of Siba Floral Decorators."
But is that in the record? Is that in the record?
It is in the record. It is in the record. That was in 2010. So I don't know how. And also, they say SFD was defunct. It's been defunct for 15 years. But in 2010, Barry is telling a news organization that it's active, and he's a co-owner of it. So it's just these things. There's a lot of mixed signal here. I think they were playing fast and loose with the corporate form, and it was. I think it was appropriate.
Can you address the fraudulent inducement claim, sir?
Sure. Well, I don't think that argument was preserved at all.
But is it a legal argument? If it's a legal argument and it's made in reply, why can't we consider it? What's the surprise? You can argue it now to say, what your position is on it.
Right? Well, it's not. First of all, it's not determinative. If it's a new legal argument, then it has to be determinative of the case, and it's not.
Of the cause of action, at least.
Okay. Well, there are also no one knew that they were moving to dismiss the fraudulent inducement claim until reply. So the court didn't consider it. We didn't get the chance to submit affidavits to let them know, hey, they told us X, and we were induced, and they produced Y.
But let's just assume that sounds like that's an insecure promise, and would that be sufficient? Excuse me, an insincere promise. Would that be sufficient to support the claim here? I mean, aren't you relegated to breach of contract?
Well, it's not an insincere promise if they knowingly made a misrepresentation that they knew was false at the time as to a future promise. There's case law on that. That is enough to sustain a fraudulent inducement claim. So it's not just an insincere promise. It's not just that they fell short. It's that they knew they wouldn't be able to deliver, and they induced us into entering into the contract anyway. That's what we alleged in the complaint. So that's all, I guess. Any other questions on that point? Because that's really the gist of that claim, although I still think it's unpreserved.
Thank you, counsel. Any other questions from the panel? Thank you. Let's go back to the appellant.
Thank you, Your Honor. Again, here I am. With respect to the rejection issue, there's actually two different statutory sections in the UCC that apply. There's UCC 2-106 sub 2, and that says that if you want to reject delivery of goods because they're not what you thought you were going to get, you have to do it. Excuse me, it's 2-602 sub 1. You have to seasonably notify them. I think that there's no dispute that they said we don't like it. The problem is 2-605 also requires that they state a particular defect and give the seller an opportunity to cure. I want my money back is not a particular defect affording the seller an opportunity to cure. So
what it strikes me, the problem with the case is to say what the particular defect here. It's sort of it's in the eye of the beholder here, because the services are more artistic, and we can disagree or agree as to whether it is an artistic creation. What I would like you to address, sir, is really the fraudulent inducement claim. Your adversary says we shouldn't consider it. It was raised in reply, and it would be essentially unfair for us to decide that now. What's your position?
Well, Your Honor, principles of law that should be self-apparent don't have to be briefed on every single motion.
Well, but you could have raised it initially, right? As opposed
When
to.
we moved to dismiss the entire complaint, our motion didn't seek to just strike certain causes of action. And we also went to great lengths in our motion to admit and establish that there was a commercial contract here. So if there's a commercial contract, we admit that there was a commercial contract, we admit that we were hired to sell them something and to deliver it, it's Hornbook law that you then can't turn around and try and turn that into a tort. When they raised it on their opposition that said, hey, you didn't mention anything about our tort claims, we then in reply, in response to their invitation said, well, that's because it was a contract. And here's all the cases that say you can't turn a contract case into a tort. The proposition is so self-evident. I was actually intrigued that it was raised on the prior argument you just heard as well. It seems to be something that comes up all the time. But our Court of Appeals has told us since the 80s that if you have a contract, if the parties don't dispute that there's a contract.
Okay, so let's just, let me stop you there for a second. So at least pertaining to the unjust enrichment promissory estoppel, there's some issue here as to who the contract's with, right? So at the very least, shouldn't those claims go forward?
Not if there was a contract. You can't.
But who's the contract with? It's not clear to me.
With the person who admitted it, and there was no refutation.
Well, but that's self-serving. I mean, it's not clear who the, isn't it? It's really not clear, right?
Actually, Your Honor, I would argue the opposite. I would say it's against her own interest. She could have hid behind the corporate form and instead, against her self-interest, volunteered that it was her who sold the product. Every stitch of paper in this case confirms that. The insurance was in her name. The W-2 was in her name. All of the invoices were in her name. The payment was made out to her. And I would add that that even the payment, everything was made before the product was even delivered. They knew that before my client ever showed up and installed the centerpiece on the table.
Thank you, counsel. Thank you both.
Thank you.
People versus Yoselin Ortega.
Your Honor, Abigail Everett for Appellate Yoselin Ortega. I'd like to start with the statements at the hospital made without Miranda warnings. The judge below was wrong to find these to be spontaneous statements. These were in response to a procedure that was clearly designed to elicit an incriminating response.
But Officer Hidalgo wasn't even investigating the crime. He wasn't assigned to investigate the crime. He was just there to watch the defendant who was in the hospital.
Right, Your Honor. But unlike a security officer who's just sitting there taking notes of anything she happens to say, the two prosecutors who were assigned to the case and the two detectives who were assigned to the case came to the hospital, called Hidalgo out in the hall. They all consulted. The detective gave him the alphabet board, sent him back in. He said, I asked her, he said at the hearing, he testified, I asked her, what is it you want to tell me? And he repeatedly asked her to clarify as she used the alphabet board.
Excuse me, counsel, wasn't it her tapping to get his attention that prompted the whole exchange?
Yes,
right?
She initiated the encounter. That's correct, Your Honor. However, that's not determinative of the question of whether what he did after that was the functional equivalent of interrogation.
Well, did he ask any questions?
He asked her, what is it you're trying to tell me? He asked her, do I understand correctly what you're saying?
So is that the functional equivalent of interrogation of this police officer who's assigned to guard the defendant in the hospital?
Yes,
is that
because it's not just the officer assigned.
Because a little bit what you're asking us to believe is that, and this case, which attracted an enormous amount of attention, they're sending in Officer Hidalgo to do the investigation. No disrespect meant to Officer Hidalgo, but that wasn't his role in this case.
Right, but the detective testified at the hearing that he had Hidalgo go in because he thought a rapport had been established between Ms. Ortega and Hidalgo. It's clear that the prosecutors in the hall, the detectives who were assigned to the case, did not want to give her Miranda warnings. This was a technique that they came up with to try to induce her to make statements.
Which the defendant initiated.
She initiated it, but as I argued, that's not dispositive. I think maybe I should move on.
Did Hidalgo prompt, maybe be a better word, the defendant to talk about specific subjects, for example?
He did not prompt him.
So doesn't that suggest that really this is not interrogation?
I don't think so, Your Honor, because it's clear that he said to her, she initially said, I have something important to say. And so he knows that that's where this is going. And this is a high profile case, a very serious case. And they could easily have given him Miranda warnings, but this is the strategy that they came up with to try to get the statement out of her without giving her Miranda warnings. This is not an officer sitting at his desk filling out forms and the defendant's in the cell and just happens to reach out and wants to talk to him. This was a strategy they all came up with together, the detectives, the prosecutors, and they sent Hidalgo in for this purpose. I'm going to move on to the jury note question point. Obviously, as we know, the court has an obligation to give a meaningful response to any jury notes, and the courts have held that it's critically important what the response is, because this coming at the end in response to a jury question, it may be determinative of the whole outcome of the case. So here we've got the jurors asking, this is not their first note, they're asking the judge to define the difference between the word conscious and how it differs from understanding. And they specifically asked the judge to speak slowly. Now, there are a couple problems with the judge's response here.
Is this issue preserved, first of all?
Yes, the defense lawyer specifically asked the judge when they conference how to respond to the note, I want you to tell the jurors, please, that understanding, I want you to repeat what you said in your original charge, that it's not just surface knowledge, and I want you to repeat that your example of a child who may be able to recite something, but they don't really know. So it's preserved to the extent that that's what the judge should have told him at the very least. And in fact, what the judge did answer was unbalanced, because the judge said they had their usual meaning. Conscious means aware, which is the least demanding of the two, but he doesn't get into understanding. And that's specifically what the defense lawyer was asking the judge to clarify, because the understanding.
But the jury specifically asked for a legal definition, did it not, of those terms?
Yes, although as I pointed.
Doesn't the judge correctly respond, there is no legal definition of those terms, either in the penal law or in the CJI?
Well, yeah, Judge, it's correct. It's technically correct, but as I pointed out in my reply, there's a case, People v. Justice, that I asked the court to look at. Just because the answer is correct doesn't mean it's a meaningful answer to the jury's question.
But didn't the judge tell the jury that if you have further problems with it, if you want me to repeat the whole charge, let me know?
He did say that, but this is the second time they've come out to talk about core issues that relate to the insanity defense. And I would point out that what the judge got into, conscious means aware, but he didn't get into understanding, which was the important word for the affirmative defense for insanity. And also, it's clear that the DA respondent argues in the brief, well, that was enough for them to understand that there's one, the conscious went to intent, and that understanding went to the affirmative defense. But the judge didn't say that these words came up in this specific context. He only said they came up in the charges, and I'll instruct you further if you want to have further information. So that since he said that there's no legal definition, he didn't give the jurors any reason to think they were going to get any clarification from the judge on this point. And if there are no further questions on this point, I do want to talk about the appeals to sympathy made during the case. Now, obviously, this is a horrendous case, and we understand that the parents are going to have a hard time testifying. What I want to stress is that in this case, the prosecutor specifically elicited the two parts of the mother and the father's testimony that prompted the defense counsel to move for mistrial. This is not just a case where the parents are having a hard time and there's some outbursts, and this is the judge, for example, the prosecutor specifically said to the father when he got on the stand, I want you to think back to that day in the hospital and what did you do? There's something you did. So he prompted the father to tell this one particular story that is just heartbreaking about how they had no blood in the bodies and they were bluish, but they still had perfect skin and long eyelashes. And the doctors had tried to get the blood out of the hair, but it was still tinged in red. And the father got down on his knees and he kissed them and he said he loved them and he was sorry. You know, how could a juror put this out of their minds? And this was explicitly brought out by the DA. And he asked the father to make this, to tell this story. And similarly, when the mother was on the stand, he said to her two things. I'm about to move on to another subject, but is there anything you would like to say? He just sort of opened the door. These are not appropriate for the fact finder to hear. In New York, we do have victim impact statements, both the father.
Let us say, Ms. Everett, that the point you're making are certainly well taken points, but does that get you to a reversal in this case? And yes, what you've alluded to is very emotional and very difficult to listen to, and I can imagine what it must have been like for the jury, but so much about the case was so emotional, it's really hard to think that these are the comments which took away the fair trial to which the defendant was entitled.
Well, two things on that, Your Honor. One, obviously the DA thought it was significant enough to bring out, particularly to bring out. And it is preserved. There were mistrial motions. And this was a distraction to the jurors. The issue, we all know the issue is insanity. So, you know, the DA, maybe this is the point to discuss the DA's argument that the insanity defense, no juror would have bought it, that the case was overwhelming. But you've got the doctor at the hospital when she immediately comes out, you know, she's taken the hospital, who says, I have experience in malingerers and experience. I diagnosed her as psychotic. I don't think she just woke up and made up psychotic symptoms. That's a psychiatrist at Presbyterian. You've got Dr. Resnick from Ohio, who's the head of a forensic clinic, who says that he testified that 60% of the time he testifies for the defense, 40% for the prosecution. He did a long interview with her on more than one occasion. He's attended to the signs of malingering. He had her talk about what kind of hallucinations she was having. He tested reality, that these made sense, that you would have these kinds of hallucinations. You have Dr. Rosenbaum, who testified as to her opinion. This was a significant insanity defense for these jurors to parse through. And many of the issues that I've brought up on appeal go directly to the jurors' ability to fairly and impartially consider that despite what the defendant did in that bathroom and the horrible things that the parents had to endure, and they discussed at trial, that the defense is asking the jurors to find that she did not substantially understand the consequences of her acts. For that reason, the court needs to weigh very carefully each and every error that occurred at this trial. I know that the brief is quite long and there are a lot of points. We don't have time to get into everything here, but this is a high profile case. This is a terrible thing that happened, but this is not the way to try such a case, to appeal to the jurors' sympathy in this very explicit
well, wouldn't it be, counsel, throughout the trial, the court was very careful to instruct the jury not to allow sympathy to sway the jury, and this would be one of those cases where it would be very important to repeatedly give that instruction. Didn't that occur here? And can't we believe that the jurors would listen to the judge? I mean, they understand that it's very sympathetic and make a decision based on the evidence and not sympathy.
Well, a couple of things about that, Your Honor. Yes, the instructions were given.
Well,
But
but they were given not just once, but they were given often, right?
they were given, I don't know exactly how many times, they were definitely given after the father testified, after the mother testified, and I think at least on one other occasion, and maybe in the final instructions. I'm not positive how many times, but yes, Your Honor, definitely the instructions were given. On the other hand, the nature of this testimony was so, I'm trying to find the right word for it, horrible, that, and to keep in mind, it's fully preserved with mistrial motions, that the defense lawyer did not think that these limiting instructions were adequate. And to keep in mind that these descriptions that I'm complaining about were specifically brought out by the DA. These are not just, I mean, I do also talk about how the mother had a hard time on the stand, and there were outbursts, and one of the limiting instructions, I believe, Kate followed that. And it's easier to see how a juror could put out of their mind that the mother was having a hard time on the stand and maybe called the defense lawyer manipulative and some of the other things that came out. But these heartbreaking stories about how she had a miscarriage and she couldn't, she wanted to tell the story of how she took solace in knowing she still had 3 children and how it broke her daughter's heart. You know, I could go on. I don't want to belabor the point, but if you look at all the things that came out, this is not appropriate in a trial of this nature. These comments are appropriate for the victim impact statements. They were made at the end of in sentencing. That's, you know, obviously these are sentiments that the parents feel very strongly, but they're not to be made in front of the fact finder. Where are we on the time here?
Thank you, counsel.
Okay,
We're
thank
over
you.
the time. Yeah, thank you very much.
Good afternoon, Your Honor. Dana Poole for the people.
Counsel, could any amount of, instructions from the court to ignore sympathy overcome the level of damage that the sympathy that was injected into this trial had, particularly where it is the prosecutor asking these questions? I mean, asking for the witness to give this information and then the court overruling objections by the defense attorney and allowing these, this detailed testimony to come into a case that is already so horrific that from the word go, no juror with any heart or mind needs to hear another word about sympathy in a case like this where they already hear the horrific facts.
Well, I think there are a couple of points with that. And one is, yes, this is a case where the horror of these killings was immediately apparent. And, you know, once the jurors heard what had happened to these children, once they saw how defendant had laid out their bloody bodies in the bathtub to be found by their mother,
we know the facts, so I don't want to hear any more of that. We know the facts perfectly.
So what my point is that these aren't the pieces of evidence that are going to sway the jury, whether or not they should have come out. I think
I have to ask you, if they weren't there to sway the jury, then why were they elicited? Why would that be elicited specifically if it wasn't to sway the jury? And then there must be an expectation that if a knowledgeable prosecutor goes out of one's way to ask those questions in order to sway the jury, then the jury must be swayed.
I don't think it's an issue of swaying the jury. I think it's an issue of these were parents who were very focused on the humanity of their children.
Of course they were. Of course they were. They're human. They just lost their children in an awful way. But that's not the job of the prosecutor to bring out that sympathy in the way that a direct question asked of a witness is designed to do.
Well, in the instance of Marina's testimony, now counsel is saying that this was preserved. It wasn't. What the prosecutor was asking about,
counsel, it doesn't seem to me that it should have come out in the first place. And now, I understand you're talking about being preserved, but there were objections in there and throughout. But I don't see
Right,
how a
and
question like that could be appropriate from a prosecutor's perspective to ask a direct question that would elicit sympathy in that way.
well, the prosecutor's question to Marina was directed at the story about her miscarriage, and that wasn't about a matter of sympathy. What he was bringing out there was that defendant had very odd reactions to Marina. Now, Marina inserted, information that I don't think would have been purposefully elicited about the reaction of Lulu.
Okay, well, let's turn to, without even going into that fully, let's, for the sake of time, talk about the father. What was the purpose of that?
Your Honor, I am not going to say that was a proper thing to elicit. I'm not making that argument, Your Honor. My argument is that the judge did offer limiting instructions that the jury is presumed to have followed. And also, there was a full month between that testimony and the jury deliberating. There was certainly time for the jurors to marshal whatever emotions had been raised by the properly elicited testimony and by these questions that, did not need to be asked in the first place. But in terms,
I was just going to say, let's move on to the issue with regard to the interrogation, or the lack of interrogation, the statements, I should say.
Right. So this was not an interrogation as it's understood in this context. It was, this is an officer who was sitting watching TV. His whole job was to simply guard the defendant, make sure nobody came in, nobody came out, and she wanted to talk to him.
But it's more than that. Is it Hispanic? Is a Spanish-speaking officer, correct?
Yes, that is correct.
So obviously there's a reason for that, correct?
That is not part of the record.
Well, wouldn't it be a fair inference that the reason why a Spanish-speaking officer is there is that if something is said so that the officer could understand what was said?
But we also don't know. I mean, he relieved someone else. We don't know whether that officer was also Spanish-speaking. We don't know about other officers who were assigned.
But when you speak about he's there, he's watching television, I mean, it is more than that, because as counsel indicated, the prosecutors and the detectives also came and were speaking to him about what to do and gave him that letterboard. So he's not simply sitting watching television, la-di-da, and she taps on the railing and she starts to talk. No, he is instructed specifically as to what to do. And then it goes on for 2 hours. Is that not an interrogation instead of mere chatting with her?
I'm sorry. He was not instructed on anything initially. Initially, he was simply...
Initially, no.
Right.
That's when he's la-di-da watching television.
Right.
And then afterwards.
Right. And then afterwards, and he is specifically instructed to not ask her questions, to simply write down or have her...
There's this use of this alphabet board, which is going to be quite tedious, especially in that condition. At some point, once the statement, should the officer have stopped whatever he was doing and taken the alphabet board, and then maybe she would have been given the opportunity of Miranda?
I'm sorry, should
well, I mean, it was 2 hours using this alphabet board. At some point, should that have stopped and maybe Miranda been given to Ms. Ortega?
Well, I don't think the alphabet board was being used for 2 hours. I think the entire time it took to take her statement. So it actually, the alphabet board didn't come in until later on during defendant's statement. And because she is volunteering information, and there is no requirement that police are supposed to stop someone from volunteering a statement, and it's clear that he's not eliciting.
So this is not any other case, of course, but as to this aspect, it is just like any other case. The police are not under an obligation to stop a defendant who starts speaking spontaneously to stop talking and say, "Oh wait, you weren't Mirandized." If they're not doing the interrogating, they don't have to offer the Miranda warnings.
Exactly, Your Honor. And so this is a defendant who quite clearly very much wanted to speak. She wanted to make sure that her siblings' phone numbers were known. She'd apparently been asking to talk to family. She wanted to have some water to drink. And then she began complaining about her employer. And, and it's clear that this isn't an interrogation because this is not what a police officer would try to elicit from someone suspected of murdering 2 children. So it's clear he is really just taking enormous efforts to understand and to allow her to say whatever it was that she was going to say, which in the end was, it certainly supports her guilt, but nothing she said proves her guilt. She did not make any confession. She didn't even talk about the children beyond saying that she was a babysitter. Besides, her personal information regarding her siblings' telephone numbers, this doctor that she wanted to see. Mostly she was complaining that the cleaning products she used irritated her pinky and that her boss kept changing.
I'm sorry to interrupt you, but I think we understand your point. Can you move on to the sufficiency of the charge that the judge gave, the response to the question, the response to the jury note, I mean.
To the jury note. Certainly, Your Honor. What the jury was specifically requesting was the legal definition of the word conscious and how it differs from understanding. Already, they had been given the context of those 2 words, first in the initial charge and then in response to the jury's first note. And so they weren't asking to be.
The question, obviously, I want you to address whether the response of the court was meaningful enough, accurate. Okay, was it meaningful in light of the question, specific question that was asked, and the fact that the question asked about understanding? They asked for a definition of the word conscious and how it differs from understanding. If you could speak to that and to the defense request to, I think, to recharge that portion of the charge that would have not specifically explained understanding, but it would have used that word in context.
Right. So again, what the jury was asking for was a legal definition. And so by the court responding, actually, there is no legal definition. It's the ordinary use of both of these words. The ordinary definition of conscious is aware. That is precisely responsive to what the jury asked. And to the extent that defense counsel had asked.
And that's why it's accurate. You're right. And that's why it's accurate. But is it meaningful given the way that the jury asked the question, the word conscious and how it differs from understanding, given that there was an aspect of the charge that used the word understanding? I'm looking for it, but I can't find the charge. But there is that aspect.
The understanding, the conscious, the word conscious is used in the definition of the murder charges, and understanding is used in the definition of the insanity defense.
Exactly.
So they had been instructed and re-instructed on both of those. Understood. And the charge that counsel was asking for, which was the understanding is different than surface knowledge, like a child who can recite but doesn't really understand the words that they're saying. They'd heard that twice already. And the judge
in response to a different question, in response to something else, in response to the initial charge and perhaps a different question.
Right. But it's clear that they were paying attention to the charges because they knew to ask for the legal definitions of these 2 words. So there wasn't an indication that they didn't know what the charges were. The indication is they wanted to know any specialized definition of the word conscious. And the court responded, there is no specific, I can't give it to you because it doesn't exist. And to allay any concerns that the defense might have that maybe they want to be recharged, he said, if that's actually what you're asking, it's not in the note, so I'm not going to do it. But if that's actually what you're going after, just send me another note. I'll be happy to do that. So Justice Caro is inviting further conversation on this if he's misinterpreting what the jury note is, and the jury doesn't send another follow-up note on that issue. So I think all the indications are not that the jury they weren't asking for this, how do we parse the history of the law and the McNaughton rule and all of that sort of thing. They were asking a very specific question. He gave a very specific answer, and offered to give more if his specificity was not answering their true concern. And since
Thank you. Are there any other questions from the panel? Thank you.
Thank you, Your Honor.
Your Honor?
Ms. Everett?
Yes. Briefly, a question came up about could the Miranda warnings have been given later in the whole process? I just wanted to point out factually that it was 750 when the board was still used. There were 750 statements, the second page of notes at 810. Then there was some notes at 950. In the middle of all this, there was this procedure where they all had to leave the room. The Hidalgo had to leave the room. They screwed something in her neck so that she wouldn't move her head for medical reasons. He came back in with the alphabet board after that break for that significant medical procedure. That's when he took the statement at 10 p.m. So this is going on a while, and all through that time, the only thing that's done without the alphabet.
It's going on a while because of the nature of the circumstances. She's in bed, she's cuffed to the bed, tied to the bed. But it's really not any different than, look, a defendant starts talking, the police don't stop the defendant from talking.
Well, they have the burden of proof on what the statements, and it's particularly suspicious that after this medical procedure, he goes back in with the alphabet board. He doesn't testify that she says, I want to keep talking, come back in so we could talk some more. He's the one pursuing it at that point. I do want to make a couple points here. The respondent made the point that the jurors were paying attention to the charges, and that's why it was appropriate, the answer the judge made. Well, it's also something the court should consider that they specifically said in this note that we're discussing, please speak slowly. There's some indication that when he previously responded to the note, or maybe even in the original charge, they found that he was speaking too quickly. So they are evincing some difficulty in understanding what's going on. So I think that's significant. And the other thing about the break between
Justice Mazzarelli, you're muted.
Not for long. But there's no indication from the jury that they didn't understand his words, that they couldn't comprehend what the words were. They were looking for a legal meaning, and he told them there was no legal meaning, that the words had their ordinary meaning, and they accepted that.
Well, Your Honor, first of all, if you look at the prior note, they also put things in terms of legal. So that's a word they use a lot in their notes. But also, I would ask the court to think that the answer the judge gave was unbalanced. The judge said, conscious means aware. That's the most surface level. The defense lawyer wanted the judge to include on the question of understanding. That's the word that's in the insanity defense. That's the one that's the most important to the defendant. The defense lawyer wanted the judge to include on that word, it's more than surface knowledge. So we got it's just aware for intent, but we didn't get the deeper answer. And the other thing I do want to just quickly point out about the gap of time between when the parents testified and the end of the case. Well, first of all, the prosecutor mentioned in summation how, I'm not making any excuses for the parents. They were heroic. There's some sort of bringing this back into the juror's mind. And so I don't think that the fact that this happened earlier in the case before the defense case gave the jurors an opportunity to put these most horrific comments out of their mind. And it's not just
what the facts are in this case. The situation is what happened, and the jury's going to know about it. They have to know what the transaction was, what happened. They have to be told about that. And that your insanity defense, the parents have to be allowed to testify in detail as to what her behavior was like. That can support your defense, or it can detract from your defense.
I have no problem with that, Your Honor, but that doesn't mean that you can have these detailed discussions about kneeling down in the room with the dead bodies and the question. earlier on, we talked about the father, but the mother, it's not just the question of the miscarriage. Before the defense.
Well, the question to the mother was open, that you mentioned earlier was open-ended.
Yeah, but it's pretty clear that he says, we're going to take a break in a couple minutes. Is there anything else you want to tell us before we take the break? And then she goes on and says, she killed my best friends. They were my best friends. I don't know how else to say it. It's awful. So obviously the prosecutor thought it was appropriate to sort of give her an open stage to just say whatever she wanted to get off her chest. Of course, she had huge emotion here, but that's not an appropriate question for the prosecutor. Just, is there anything else you'd like to tell the juror before we move on to something else? I mean, it's clear that for whatever reason, this prosecutor thought it was appropriate to let the parents, the tragic parents, just vent. So for that reason, I asked the court to reverse.
Thank you. Thank you both. Matter of Brooklyn Legal Services versus New York City Taxi and Limousine Commission.
Good afternoon, Your Honors. Allison Langley for Brooklyn Legal Services. We are here today because the Taxi and Limousine Commission denied petitioner's FOIL request for anonymized fitness interview decisions. FOIL was implemented to codify the people's right to know the process of governmental decision-making. And this is precisely the kind of information—
Counsel, does the DPPA control here and limit the amount of information that would have complied with the FOIL?
No, Your Honor, it does not. The Federal Driver's Privacy Protection Act prohibits the disclosure of personal information only, which is defined by the statute to mean, quote, information
So
that—
you offered, Counsel Judge Friedman, you offered for there to be redactions. Why didn't anyone here on either side request that the court to do an in-camera inspection, at least some of the sample of the materials that would have responded to your request, to see whether or not it's possible to redact it and still protect the confidentiality of the parties involved?
Absolutely, Your Honor. The petitioner submitted a redacted example of a fitness decision that's in the record, and I can point you to that if you desire that. And so we did not at the time feel that it was necessary to ask for an in-camera inspection because we believed that the record was sufficient to show that the redactions we asked for were sufficient to protect applicants' privacy. However, we are, of course, open if the court believes it's necessary for that to happen on remand. But we argued that the DPPA plainly does not apply, and so Section 87(2)A of the FOIL is not triggered. As I was beginning to mention, the DPPA protects only personal information, which is defined specifically in the statute as information that identifies an individual, and it lists examples such as social security number, driver ID number, name, address. And as Your Honors have pointed out, we specifically asked that that information and any other information that could be considered personal identifying information pursuant to the DPPA or otherwise be redacted. And as such, we do not believe that the DPPA applies here. Of course, the TLC argues that it not only applies, but that it protects the whole document of the decisions from disclosure. This argument fails for two reasons. First, the line of cases that respondents cite to refer to statutes in which the whole record or all information provided in a particular context is protected. That's simply not the case here. The language of the DPPA is plain. The statute is titled Prohibition on Release and Use of Certain Personal Information from State Motor Vehicle Records. And the text of the statute reiterates this distinction between the personal information that is protected as well as the motor vehicle record itself, which is not protected. The FOIL also contemplates that only portions of records may be protected. Section 87(2) states that an agency may, quote, deny access to records or portions thereof that are, specifically exempted from disclosure by state or federal statute. Second, even if petitioners were to concede to TLC's overly broad assessment of what, if anything, is protected under DPPA, only the portion of the fitness interview decisions that are derived from the DMV records and not the entire decision would be exempt. As an entirely independent and novel document, the decisions cannot be considered a DMV record and as such would not be protected from their disclosure in their entirety. For all of these reasons, Section 87(2)A simply does not apply here. Next.
Thank you. Oh, sorry.
Oh,
Go ahead. You have another minute.
Yes, okay. The disclosure of the decisions would not create an unwarranted invasion of personal privacy pursuant to Section 87(2)(b). The FOIL is clear in Section 89(2)(c) that disclosure shall not be considered an unwarranted invasion of personal privacy where identifying details are deleted. The TLC must have a factual basis for their assertion that documents cannot be redacted in a way that would protect applicants' identity. The TLC, upon review of the record, has plainly failed to meet this burden. They rely solely on an affirmation from an attorney that it's possible to identify some applicants because they may have been subject to media coverage. Meanwhile, the only sample redacted decision in the record shows that this is incredibly unlikely. The narratives are general and they simply do not include the level of detail that would be necessary for this to occur. In similar situations, courts have consistently held that speculation without more that it may be possible to discern someone's identity is insufficient to meet an agency's burden. Finally, even assuming an invasion of personal privacy that does not exist here, this would be weighed against the public interest. Here, there's a strong public interest in ensuring equitable access to the many jobs that TLC licensure provides, and it's essential that people with criminal convictions have access to this path to employment. Indeed, it is so essential and of such public interest that it's been codified in Article 23A of the Corrections Law, which prohibits discrimination against people with criminal convictions when considering whether they're fit for licensure. Unfortunately, courts have historically found that the TLC unlawfully discriminated against applicants with criminal histories, but not all applicants are aware of their rights or have the resources to bring individual cases. As such, widespread review of the standards would allow advocates, such as petitioner, to know if more advocacy is necessary to prevent future discrimination. For all of the above reasons, Section 87(2)(b) does not apply here. In conclusion, oh yes, thank you.
Thank you. Respondent?
Good afternoon, Your Honors, and may it please the court. Amy McKempel on behalf of the respondent, TLC. Your Honors, there's two different FOIL exemptions here that justified TLC's withholding of the requested records. So starting with the confidentiality exemption, all parties agree that there is confidential information protected by federal statute within these fitness interview decisions. Now, petitioner argues that—
Counselor, does that mean that all information is excluded?
No, Your Honor.
Well, if all information is not excluded, let me finish. If all information is not excluded, why can't personal information be redacted and then portions of the DPPA that are not excluded remain?
Well, the reason is, Your Honor, is that there's no requirement for an agency to redact documents when the agency has demonstrated that a federal or state confidentiality statute applies.
But the statute, as your adversary points out, it's a limited exclusion. It's not like, for example, with respect to the grand jury where there's an absolute exclusion. So why, again, since it's a limited exclusion, why shouldn't you provide redacted documents that protect the privacy?
The reason why, Your Honor, is because FOIL distinguishes between contexts in which redactions are required, which is the privacy exemption, and contexts in which there is no requirement for agencies to make redactions to comply, and that's the confidentiality exemption. We've cited a line of cases in our brief that make that distinction, and the petitioner hasn't cited a single case in which an agency was ever required to make redactions to comply with confidentiality. It simply hasn't happened. So for that reason, TLC was justified in withholding the records in full because the confidentiality statute applied. And the second exemption that applies here, Your Honors, is the privacy exemption. So the only dispute between the parties is whether the personal privacy of the applicants will be sufficiently protected if their names and addresses and other identifying details are redacted, as petitioner has requested. And here, TLC has demonstrated that that would not be sufficiently protective of personal privacy because the records—
How have you demonstrated that?
Sure, Your Honor, because we discussed how the records at issue contain detailed narratives about the applicants. And an interested party could extract information from these narratives and couple it with other information, publicly available information online, in order to determine the identity of the applicants. And this court has recognized that when redaction is not sufficient to protect personal privacy, an agency is justified in withholding the records in full.
Wouldn't an in-camera inspection be a better way to sort of test that theory of yours as to whether or not that's possible? Because how do you expect the petitioner to respond to it without that kind of in-camera review before the court?
Well, as my adversary pointed out, the petitioner submitted a sample to the court. The court had that before the trial court, so it saw what the records were like, and the court agreed that the TLC had made the showing that redaction would not be sufficiently protective of personal privacy here. And I think an important point to keep in mind, Your Honor.
The court seemed to do that, if I might, the court seemed to do that only under the DPPA, which my colleague has pointed out is not a blanket, prohibition to this information. So it's not clear that the court was really considering it.
The trial court also discussed the privacy interest of the applicants here and how the privacy interest justified withholding the records. And an important point to keep in mind, Your Honors, is the balance that courts do between the privacy interest and the public interest. And here, Supreme Court correctly found that the privacy interest of the applicants justify withholding these records because these narratives in these records contain very personal, very sensitive information. A lot of the records. Can I
ask you, by the way, a practical question? If there isn't any information about, name, race, or maybe there is race, name, identity, all of this, how would this information, as detailed as it might be, how would one be able to connect that to a particular person? There are some 4,000 cases here.
Well, there are details about the person within the narrative, Your Honor. So the narrative. I
understand that, but I mean, what kind of detail would be able to allow someone to backtrack, without a name, without an address, without how is that? Is that really realistic? That argument?
Well, Your Honor, there are a lot of details in the narratives because they are talking about.
Details if that's the concern, can't at an in-camera inspection or an in-camera hearing, can't those kinds of details be redacted because you understand that the petitioners have a very specific request as to why they want that information. It doesn't sound to me like that kind of information really concerns those issues, right?
Well, I think the problem, Your Honor, is that the information that could be used to identify people, in a lot of cases, that is the heart of the information that petitioner is looking for, because petitioner wants information on the basis of TLC's discretionary determination. And that's based on the history of the applicant, talking about their past crimes or past driving violations, their personal reflections. So all of those details form the basis.
And that's why I go back to my question. Practically speaking, how would anybody be able to backtrack that information so you have that somebody did a petty larceny. How do you figure out who that is in the world of people who committed petty larcenies? I mean, how would any of this information be able to be backtracked? And if it could be, what amount of money would the legal aid or whoever's doing this be able to spend for the kind of complicated equipment and people who could do that? I mean, that's not their goal is not to look at this detailed information to go back and figure out who said it.
I understand that's not the goal of the petitioner here, Your Honor, but TLC is concerned about the privacy of the applicants if these become public, because again, these are incredibly sensitive documents. They talk a lot about, in many cases, applicants' past crimes. They may talk about mental health issues, substance abuse issues, and the applicants' personal reflections on this.
I agree. I guess my point is, even if it became public, how practically speaking, would one be able to backtrack? Thank you. Let's hear from
Your Honor.
Counsel rebuttal.
Thank you. So for a few different points. First, petitioners have made it clear since the beginning that we're seeking an anonymized set of facts. And so to the extent that there are details which could possibly be used to identify someone, which we argue simply doesn't exist in these decisions, but should they exist, we are fine with redaction. What we would like to see preserved is the grounds on which the TLC is making their decision and how they're using the prongs of Article 23A, which outlines the allowable things they're allowed to consider when making decisions based on criminal convictions. Second, to the extent that my opponent relies on the Supreme Court's decision, I would like to reiterate that the Supreme Court used the wrong standard of review. She used the arbitrary and capricious standard, which grants significant deference to the respondent agency, and Article 78, brought pursuant to the FOIL, have a higher standard of review because the FOIL operates on a presumption that government records are available for review. And as such, the agency must squarely prove that a statutory exemption applies, which they plainly have not done so on this record. As to my opponent's point that there's a line of cases which say that redaction is not necessary if section 87(2)(a) is triggered. That's truly all of the cases they cite refer only to instances in which the confidentiality statute at issue protects the whole record or all information. That is simply not the case here. And as such, those cases are inapposite.
Thank you.
Thank you so much.
Thank you both. AMBAC Assurance versus Countrywide Home.
Yes, Your Honor. May it please the court, Diana Connor of Patterson Belknap on behalf of Appellant AMBAC Assurance Corporation. This case presents the question of whether, under New York's 2-year fraud discovery rule, a plaintiff can have its claim dismissed as time barred before it could have even been brought. A question which is—
This is a 6-year statute of limitations on fraud, and clearly that has passed. You're talking about the 2-year, as you just said, from discovery.
Yes, Your Honor.
In this case, why don't you have inquiry notice based on all of the cases we have? In the Aozora cases, the CIFG, why didn't you have inquiry notice here?
Your Honor, excuse me, Your Honor, we submit that we were not on inquiry notice and that Countrywide hasn't demonstrated that. But even setting that issue aside, the second prong of the test is clearly not met here because AMBAC has demonstrated that it could not have discovered the basis for its claims with reasonable diligence. If AMBAC had
just didn't AMBAC put out some representation that they were aware of the fraud and they were actually going to investigate all avenues of fraud or something to that nature?
Yes, Your Honor. And at this time, AMBAC was investigating where it had the means to do so. Critically, what that meant is that where AMBAC had a contractual right to access the loan files and dig into the veracity of Countrywide's representations.
But you're
about
talking
the loans,
about this
it was
loan
doing so.
specific. I'm sorry to interrupt you. You're talking about this, details of individual loans, this kind of loan specific information that might be for an actual fraud complaint, but we're just talking here about whether or not you would have been on notice to begin such investigation. And the cases don't suggest that you have to have that level of detail, that you need to go into the loan. Justice Singh, I think, had a question.
I just wanted to add, because what we're talking about really is a systematic underwriting failures, right? So the question is were you on notice of systematic underwriting failures by Countrywide going back to 2008? And I refer your attention to, for example, with your 10K filings. It sounds to me that you were on notice back then that there were serious issues with respect to Countrywide's underwriting.
Your Honor, we submit that we were not on inquiry notice of the particular fraud at issue here, but again, that's not sufficient. That's not the end of the inquiry. There's a second prong to the test about reasonable diligence. And this court has made clear in its decision in Norddeutsch that the question of whether a plaintiff could have reasonably, with reasonable diligence, uncovered the basis for its claims depends on whether it had enough information to plead its claims. And that rule makes sense because without enough information to plead its claims, a plaintiff cannot actually bring the claims.
Well, in 2009, why didn't they have enough information to plead their claims? I know there's some case law afterwards which spoke about the details of what has to be in such a complaint, and maybe you would have had problems meeting that standard. But the operative date here is November 21st, 2009, and at that point, you did have enough information to bring your claim.
Respectfully, Your Honor, we did not, because the pleading standard, as Your Honor alluded to, was very strict at that time. And Countrywide knows this because it was arguing for this standard successfully. Courts were requiring plaintiffs at that time to plead allegations about loans and the particular transactions at issue. Otherwise, their claims were being dismissed. And Countrywide has not identified a single case to the contrary, allowing a claim to go forward without those kinds of allegations. And Countrywide obtained a favorable ruling in its favor in the case.
What did you present in the record? What did you present in the record of this case, of the efforts that AMBAC made to verify what the details of the fraud were? Did you set forth an affidavit detailing the investigative steps that you took and that you are not able to succeed at because of a lack of information?
Yes, Your Honor, and this is at page 1453 and 1454 of the record. We lay out what AMBEC was able to do.
Even now, your complaint is not really focused on individual loans.
Yes, Your Honor, it is. While our complaint includes background information about Countrywide's general misconduct, critically, it connects that to these transactions and the loans in these transactions.
But
and AMBEC
Counselor,
was able to do so because of the
Counselor,
loan
you
file
connected
review.
those transactions back in your own SEC filings back in 2008.
No, Your Honor, we did not connect it to these transactions. And more importantly, we couldn't have pled a claim about these transactions under the pleading standards that were prevailing at that time. Because as Countrywide well knows, courts were dismissing complaints where plaintiffs weren't able to connect generalized allegations. Countrywide itself argued, and if you look at pages 981 to 984 of the record, it's Countrywide's brief from 2009 in the Footbridge case. Countrywide's arguing that the standard is a plaintiff must tie generalized allegations to the loans at issue. And AMBEC was unable to do that. And as Justice Friedman was asking, there is record evidence that AMBEC submitted, and this is on a motion to dismiss. Record evidence showing that AMBEC didn't have access to the loan file at that time, and it couldn't have accessed it. It wasn't until 2010 when AMBEC was placed in statutory rehabilitation. And then in 2012, when state regulators used their subpoena power to intervene on AMBEC's behalf to obtain the loan files, that AMBEC was able to access this information. And Countrywide has not disputed these facts. These facts must be assumed to be true for purposes of this motion. And the trial court was required to give AMBEC's evidence its most favorable interpretation. At the very least here, there's a question of fact as to what else AMBEC could have uncovered with reasonable diligence when it had no access to the loan files. And therefore, because it couldn't access the loan file, it couldn't meet the pleading standard at that time. Only later down the road did the pleading standard loosen enough that such information wouldn't have been required.
How do you distinguish the cases referred to my colleague before, the Azora cases? There are two cases here which seemingly are on point with respect to what the market practices, what was known in the media at the time, that was sufficient to put you on inquiry notice or put a plaintiff on inquiry notice.
Your Honor, we submit that those cases are different because with respect to inquiry notice, because we didn't have transaction-specific information, but even setting aside the inquiry notice prong, that doesn't end the question. There's a second prong to the test, reasonable diligence. And the way we would distinguish those cases is that in those cases, this court said the plaintiff hasn't shown what changed. They didn't show why they couldn't perform the same investigation years earlier. AMBEC has shown that. Critical new information came to light that AMBEC wasn't able to access until 2012, 3 years after the cutoff date in this case. And so this is a very different case, and we have at least raised an issue of fact on the question of whether AMBEC could have actually discovered the basis for its claims and adequately pled a claim. This places AMBEC between a rock and a hard place. It's a complete catch-22 under Countrywide standard, because under their standard, in 2009, the statute of limitations begins running, but AMBEC cannot actually assert a claim. So it just has to wait around while the 2 years.
But why can't you assert a claim for fraud based on the underwriting practices and saying that your damages are not ascertainable at this point because that's something that's going to occur when payouts are made in the future? Why wouldn't that be sufficient?
That was not sufficient under many cases, every case prevailing at that time, including the Footbridge case in which Countrywide itself obtained a favorable ruling, the Plumbers Union case, the United Guarantee versus Countrywide case. Every single case during this period dismissed claims like that based on generalized allegations. So the proof is in the pudding here, Your Honor. And Countrywide is judicially stopped from arguing otherwise.
It's hard to think that where the certificates are downgraded from AAA to junk by February of 2009, you aren't on inquiry notice about these certificates.
Your Honor, even accepting that point, and let's say that we were on inquiry notice, that doesn't end the analysis because being on inquiry notice isn't enough. The Countrywide had to show conclusively that AMBEC could have actually uncovered the basis for its claims, and as this court said in the Norddeutsch case, actually plead a claim. It is clear based on the prevailing law as of 2009. You need only read Countrywide's briefs in the Footbridge case to see.
So specifically, what steps did you take before 2009 to investigate Countrywide? What specifically did you do?
Your Honor, it's a limited record because we're at a motion to dismiss. It's not clear that AMBEC was able to take any steps, but critically, that also doesn't end the inquiry because the question is what a reasonably diligent inquiry would have uncovered. As this court said in the CSAM case, would have actually developed the truth. If there was no inquiry available to the plaintiff that could have developed the truth here, because AMBEC couldn't access the loan files that it needed to actually plead a claim.
Of course, if no inquiry was made, the truth wasn't going to be uncovered. If no effort was made, clearly nothing was going to be found out.
But Your Honor, this court has repeatedly held that that's not the end of the question. In the HealthWave case and the Epiphany case, this court held that where the inquiry available would have been fruitless, and here it would have been futile, because AMBEC knew at that time that Countrywide would not turn over the loan files. It was rejecting AMBEC's request for loan files, even where AMBEC had a contractual right to those loan files. Countrywide was saying no. So AMBEC knew that Countrywide wasn't going to nicely turn them over just because of that.
Are you suggesting you didn't have a remedy under those circumstances to come into court and ask for loan files? I mean, I can think of a few remedies that you might be able to exercise to be able to get discovery in order to, for example, to bring a cause of action.
Your Honor, if we had asserted a claim at that time, it would have been dismissed before we got to the discovery phase, because we didn't have access to the loan files.
If you had sought discovery in support of bringing a cause of action, that would have been dismissed in the face of all of the reports of fraud in these transactions, and the fact that there was other litigation relating to these transactions, and the downgrade from AAA to junk. You don't think you would have had a basis to ask for discovery in support of bringing a cause of action?
Your Honor, the plaintiffs who did so during this period had their fraud claims dismissed before they even got there. The proof is in the pudding.
We're not talking about.
Thank you.
We weren't talking about bringing the action. We're talking about seeking discovery.
Your Honor, at the very least, there's an issue of fact as
Counsel,
to what a reasonable.
you can respond on rebuttal. Thanks. Let's move on to your opposing counsel.
Good afternoon, Your Honors. May it please the court, Rachel Sparks Bradley of Simpson, Thatcher, and Bartlett on behalf of defendant respondent Countrywide Home Loans. All this talk from AMBEC about loan level re-underwriting analysis, catch-22, judicial estoppel is after the fact diversion from AMBEC's.
Counsel, can you just address AMBEC's representations of reasonable diligence, that they would not, no matter what path they would have taken, they wouldn't have been able to plead that sufficiently back in 2009?
So 2 points on that, Your Honor. One is there is nothing in the record to give any indication that AMBEC ever requested or sought loan files at any point before 2012. It does not exist. And in fact, if you look at the declaration, or excuse me, the affidavit that my opposing counsel just pointed you to, it in fact is very artfully worded to avoid saying when AMBEC first requested loan files, but it is very clear that it was not
something
before
about not having the
2012.
tech. Sorry, I think they say something about not having the technology to be able to access the information that they would have needed from the loan files. So that's why there would be nothing before 2012.
The technology, Your Honor, respectfully, I understand the technology is a separate question. The technology is a question with respect to whether certain loan schedules that contain information can be evaluated. Now, we dispute that AMBEC would have had access to this technology as it was widely available by 2010. But regardless, that's not the loan file issue. It's a separate issue. The other point I would make, so there's really no question of fact that AMBEC did not do anything in response to, I think, very clearly being on inquiry notice. The raft of litigation, the ratings downgrades, including with litigation and other issues with respect to the very type of collateral at issue here, these pay option arms. You know, for AMBEC to come in now and say, oh, we had no idea that there could potentially have been fraud at Countrywide doesn't seem very legitimate.
I don't think that's what they're saying. I don't think that's what they're saying. I think they're saying we didn't have enough to establish this without expecting to have our claim dismissed. I think that's what they're saying.
And thank you, Your Honor. And to respond directly to that, AMBEC has accused us of not citing a single case in which a claim without loan level re-underwriting analysis survived. They point to not a single case in which it didn't, other than this 2010 Footbridge case, which again was under a different standard, asking a different question. When you look back at the cases from 2008, 2009, 2010, as you know, the law about RMBS and what was necessary to plead fraud claims was continuing to develop, what's very clear is that these claims were not completely barred. By no means. We cite a number of these at pages 26 through 30 in our brief. At the very least, what AMBAC could say is that the case law was developing. Cannot say, as it has said, that the courthouse doors were completely shut to it. That simply is not an accurate representation of the law at that time. There is no catch-22 for AMBAC. At 2009, it was on inquiry notice. It then had 2 years after that to inquire, to investigate. So it had until 2011 to file its complaint.
And counsel, your adversary suggests, at least, or argues that the pleading in this case really is based on a loan by loan basis. Is that accurate, or is it really alleging a systematic underwriting failure by Countrywide?
Well, I think, Your Honor, as the court below found, it really is about widespread systematic underwriting failure at Countrywide. That is the crux of the complaint. At the end of the complaint is tacked on.
Even now, isn't that so? Even now.
Even now, that's correct, Your Honor. So in the complaint, it's 16 of 253 allegations. They're added as a way of, in AMBAC's words, to confirm this, what they call the systematic underwriting failures at Countrywide. It's a very small part of the complaint, and that's the only piece of it that they could not have filed in a timely manner within that 2-year inquiry notice period. I would add one other thing.
Was there ever a demand, or in the record, is there a demand for loan files prior to 2009?
Not to my knowledge, Your Honor. Not prior to 2012.
So when was the first time in the record there was a demand for the loan files?
I believe it's 2012, Your Honor. I think it's worth pointing out that AMBAC actually didn't even want to litigate this case in New York. They brought it in Wisconsin to take advantage of what was believed to be a more favorable statute of limitations. And in dismissing the case there on personal jurisdiction grounds, the trial court said, quote, AMBAC brought this case here because it has a statute of limitations problem in New York. It was recognized by the court there. AMBAC lost at every level in Wisconsin on personal jurisdiction grounds, all the way up to the Supreme Court there. Once that avenue was closed to it, it then came back here to New York saying, oh, now let's try to figure out a way to get around the statute of limitations. And respectfully, Your Honor, Justice Friedman below saw right through that. It cannot be gotten around. They were on inquiry notice. They failed to conduct the reasonable inquiry, and the case was properly dismissed.
What you've just said is that they didn't even seek the files until the 2-year inquiry period had elapsed.
Yes, Your Honor, which seems to be the end of the question right there. That there was no reasonable diligence if they're not even looking for the thing that they claim they had to have.
Well, presumably, I think they would respond is that they couldn't really seek the files until they had a lawsuit. Would that be a fair statement?
Well, I think if I understand what AMBAC is saying, they're saying they don't have a lawsuit until they have those files. So I would think that they would need, their argument seems to be that they needed those in order to bring a complaint. But there's certainly no checklist that says they have to have those files before filing. They don't have to have a bulletproof complaint tied up in a bow.
Could you seek pre-action discovery for that?
Your Honor, AMBAC never did. So I think, I don't know. I don't know because AMBAC never pursued. They did nothing in response to being on inquiry notice of potential fraud at Countrywide regarding these transactions.
Thank you. Let's get back to Ms. Connor.
Thank you, Your Honor. First, I'd like to address the concern about whether the crux of AMBAC's complaint is generalized allegations about Countrywide. AMBAC has no claim against Countrywide that's just based on generalized allegations. AMBAC's claim is that AMBAC was defrauded in connection with the transactions in which AMBAC was the insurer. That is the only way in which AMBAC is injured by Countrywide's misconduct. So while AMBAC included, we concede, background information about Countrywide's other wrongdoing to shore up its complaint, the crux of its complaint is that it was defrauded by Countrywide in connection with these 5 transactions. That wasn't, fortuitous, just tacked on at the end. It was critical. It was the core of the complaint. And without it, AMBAC had no claim against Countrywide in connection with these deals. Second, I'd like to address the question of what the pleading standard was in 2009. It was not developing, as Countrywide counsel says. It was developed. And every single case that in which a plaintiff tried to assert a fraud claim without loan level allegations, it would have been dismissed. The cases that Countrywide disingenuously cites in its brief from 2010 and 2011, those are non-fraud cases. They're cases in which there wasn't a heightened pleading standard of having to plead fraud with particularity. So they're completely irrelevant and tell us nothing about whether fraud plaintiffs were required to include allegations about loan levels. They indisputably were. And Countrywide is judicially estopped from arguing otherwise here because it obtained a favorable ruling and in its favor in the Footbridge case. And so Countrywide cannot identify a case before 2012. It talks about the FHFA case. That was in 2012. That loosened standard would have been of no help to AMBAC in 2009, which is the relevant cutoff date here. And I'd like to get to the question of, given that that was the pleading standard, Countrywide has no answer to what AMBAC was supposed to do. Countrywide essentially says, too bad, you just have to wait around for the statute of limitations to tick away, even though you had no access to the loan file.
But that's I'm sorry. I really have to stop you there. It's hard for me to agree with that statement because you certainly did have remedies in terms of making demands for loan files. If they didn't provide loan files, you presumably had contractual rights to loan files.
We did not, Your Honor.
Okay, well then you could still bring you could have, without much difficulty in New York, brought a special proceeding seeking a pre-action discovery in order to frame a fraud complaint in the style you are asserting.
Your Honor, there's at the very least a question of fact here as to what AMBAC did and could have done, whether any further available inquiry to it would have been completely fruitless. Countrywide is now saying, oh, they could have asked us.
Where is the question of fact when Judge Singh poses the question, why didn't you seek pre-action discovery? What's the factual question?
Your Honor, there's certainly a question as to whether a reasonably diligent plaintiff sitting in AMBAC's shoes in 2009, seeing the pleading standard as it was, would have had to go to the lengths of pre-action discovery to be able to try to obtain those loans.
With the market for these certificates disintegrating, there's a question about that?
Yes, Your Honor. Only
and there being
reasonable
other
diligence.
litigation on this subject?
Yes, Your Honor. Only reasonable diligence is required, not heightened diligence. This court has emphasized that time and again, including in the Healthwave case cited in our brief. And so to say that, and Countrywide has not even disputed AMBAC's evidence. It submitted nothing to the record. It has not made this argument of pre-action discovery or other means that AMBAC could have obtained the loans. Countrywide has submitted nothing in this appeal. And so it must be considered as true for purposes of this motion and this appeal that AMBAC didn't obtain the loan files and it couldn't have. And it should have been left to the trier of fact as to whether a reasonably diligent plaintiff could have uncovered the basis for its claims. Under the Court of Appeals decision in Sargis, Countrywide had to make a conclusive showing that AMBAC could have discovered the basis for its claims earlier. Countrywide did not even try. And the trial court should have left this to the trier of fact. Thank you, Your Honor.
Thank you. Thank you both. ED&F and Sugar Limited versus George Gellert.
Good afternoon, Your Honor. My name is Jeffrey. Yeah, my name is Jeffrey Miller. I represent the appellant. May I proceed?
Yes.
Thank you. So,
Mr. Miller, let me just ask you a question right out of the box, and that is your client entered into the loan agreement, right? Here in this instance?
there's multiple agreements, right? There's a guarantee, and then there's two separate underlying agreements remaining.
And your client entered into the loan agreement here, the underlying agreement?
When you say my client,
there's a loan agreement that has Romania as the law that governs that loan agreement.
That's
your
right.
client entered into that, right?
That was entered into, correct?
By your client.
By Mr. Gellert and by the two Romanian entities.
Right. Okay. I'm sorry, not by your client, by Mr. Geller. I'm sorry. Yeah.
Yeah. Well, You focused on really what the issue is in the appeal, Your Honor, which is that, first of all, I think that dispositive law that governs the issues in the case, and that is that where there's enforcement of a guarantee is either dependent or conditioned in any way on an underlying agreement, this court has repeatedly said, and I think it's there's no contrary case law from this court, that the underlying action can't move forward. And I think, you know, everyone here understands that the sound reasoning behind that is that you can't have inconsistent decisions. But more importantly, if Mr. Gellert guaranteed a debt by an underlying company and the underlying company doesn't owe the debt, he can't be sued to pay it. He can only pay it if the underlying debt is owed.
So your strategy, to be very transparent about it, is to get the loans thrown out in Romania, and then when Mr. Gellert is sued in New York, and the guarantee provides that this is to happen in New York, there'll be no guarantee because there's no loan left that's owing.
Yeah, Your Honor, and we're calling them the loan agreements, but really the whole structure was that there was a business relationship between these entities and the respondent, and it was to supply sugar. And there is a value-added tax called a VAT tax, which is a tax which is in Europe but is not here, and the parties didn't collect that tax. And the Romanian authority came and said, you owe us a lot of money for this tax. So the parties to this action got together in these underlying Romanian agreements and said, okay, the respondent is going to pay the money, but paragraphs 3 to 8 of both of these agreements, which are on paragraphs 26 and 32 of the record, specifically address when the money will be due. And paragraph 7 specifically says that the payment is only subject to Mann, who's a respondent's compliance with paragraph 3 of the agreement. And paragraph 3 of the agreement specifically provides that Mann has to use its best endeavors for a period of 24 months to collect the debt. Now, in their opposition to this appeal, the respondent kind of glosses over that point by saying, well, they talked to the authorities, they had an accounting firm named PMG talk to the authorities, but there is a dispute in Romania, which the parties agreed to be governed by Romanian law, about whether Mann met its condition precedent to the debt being due. It's not like this debt is due and they're trying to sue on it here in New York. There's a question about whether it's even due in the first place. And if this appeal isn't successful, what will happen is the guarantee action, which is in New York with a New York venue provision and a law provision, will go forward, and my client will have to litigate in a New York court whether these companies owe the debt under these underlying Romanian agreements, which the parties had agreed at the outset of this relationship would be litigated in Romania, subject to Romanian law. And
Thank you. Yeah. Thank you. I think we have your point.
Thank you.
The respondent.
Thank you, Your Honor. May it please the court. This case is a one-count.
So what do you have to say to that, which counsel says that your client entered into the loan agreement knowing that it was going to be litigated in Romania, and it should be litigated there first? The loan agreement will determine the outcome of the guarantee.
Because it's not true what my adversary said, that this court has.
Well, what part's not true? Does it say in the loan agreement that Romania is the place that it should be litigated?
The agreements.
Romanian law. Sorry, go ahead.
Sorry, Your Honor. Yeah, I'm sure. The two agreements with the Romanian entities that were loan agreements that were entered into by my client do provide that they are governed by Romanian law, and they provide that disputes related to them should be decided by a Romanian court. But that is not what the guarantee says, and no decision cited by the appellant, no decision that we've found, says that to proceed against a guarantor, you first have to proceed against the underlying obligors, which in this case.
So let me stop you there for a second. How can there be liability under the guarantee if it's determined that there's no liability under the loan agreements, right? So aren't you putting the cart before the horse in effect?
Your Honor, the issue whether there is underlying liability of the obligors can be decided by New York Supreme Court.
But doesn't that violate, Steve, but that's the issue I'm having. Doesn't that then violate the loan agreements where it was agreed that those issues would be resolved by a Romanian court? And that in effect, what you've done is you've done an end run by bringing this lawsuit under the guarantee first in New York.
Your Honor, the end run here has been effected by the appellant. The appellant's position requires, as a precondition to the enforcement of the guarantee, that ED&F proceed directly against the Lamarco entities in Romania. And that fundamentally changes the nature of the right given to ED&F in the guarantee. That right does not require a separate proceeding in Romania. And to infer such.
So laying it out. So we go. The case gets litigated in Romania. Case gets litigated here, and we have inconsistent decisions. Then what? What is the appellate division to do at that point?
Your Honor, this court has not said that the prospect of inconsistent decisions necessarily requires a stay. And we've cited the Island Intellectual Property case by this court in which one side was requesting a stay based on a separate action that was trying to invalidate patents underlying the contract that was at issue in the case. And the court said it was within the court's discretion not to stay that case. And the same is true here. And I would also add,
it's within the court's discretion, but what is the rationale for litigating the guarantee when you don't know what's going to happen with the loan?
Your Honor, it's not a matter of not knowing, it's a matter of which court decides. And the guarantee says that New York Supreme Court decides.
So just using that procedure, isn't it proper to stay this proceeding, let the Romanian courts, in accordance with the loan agreements, decide the issue whether or not there's an underlying debt, and then the guarantee gets resolved by the New York State Supreme Court with that provision?
Your Honor, appellants have repeatedly said in their papers that there would be nothing left for the New York Supreme Court to decide if that issue were decided by the Romanian court. And
well, what do you say happens if the Romanian court says there's no loan due? What do you say happens to the guarantee?
I don't think New York Supreme Court would be bound by that decision because it's a pure issue of law, which doesn't have collateral estoppel.
But you agreed for Romania to decide whether there's a loan or not. And if the Romanian courts decide there's no loan, New York courts should disregard that if the contract says Romanian courts decide whether there's a loan?
Your Honor, the agreements did not require ED&F to affirmatively prosecute this issue in Romania. If appellant's position is accepted, it would render the right to bring this action in New York nugatory. It would nullify that right. And in repeated cases that we've cited in respondent's brief, this court has said that when you have related agreements with different forum selection clauses, you treat them independently. And you don't have this Byzantine procedure advocated by appellant where you either have to wait for the Lamarco entities, which are defunct right now, to start an action in Romania, or wait for Mr. Gellert to start an action in Romania, or proceed in Romania yourself before exercising your right to proceed in New York. That right was bargained for. Thank you, Ron.
You finished your thought?
Yes.
Did you finish your thought? Yes. Okay. Thank you. Back to Mr. Miller.
Thank you, Your Honor. So counsel said that, Justice Singh asked a question, would this be an end run around the Romanian statute, Romanian law provision? And honestly, that's exactly what it is, because it's not only an end run. What the respondent did is they went to court and they filed first. And they're saying, since we filed first, the claim should be litigated here. But that's not even a relevant factor, because if you allow the case to be litigated and decided here, you will have rewritten the venue selection clause and the jurisdiction clause.
But then how do you respond to your adversary? Because your adversary says that they're independent agreements, so they're entitled to. It's discretionary for the court to decide, and it denied that, and therefore we're seeking just to enforce our rights under the guarantee in accordance with the guarantee.
Yeah, but Your Honor, the point that's missing there is that in order to enforce the guarantee, the money has to be owed. A guarantee doesn't exist in space. It was signed at the same time as the Romanian agreements. And the parties agreed that to decide whether the money's owed, it happens in Romania. Once that's decided, or even if it's not contested, in other words, it's not a precondition that it has to be decided in Romania. Maybe it's not contested. They could sue here. There might be other defenses to the guarantee. Maybe it wasn't signed. Maybe there were issues. But the one precondition that was agreed to by the parties was that if there was an issue about whether it was owed.
Is that a precondition in the guarantee? Does it actually state that as a precondition in the guarantee?
If you look at the guarantee, Your Honor, which is on page 22 of the record, and you look at you read paragraph 4 in full, it says at the end that they can collect unconditionally on the guarantee per the 2 agreements attached. And those 2 agreements are the Romanian agreements. And if you look at the Romanian agreements specifically say you can only collect on this money we're giving you if and only if you used your best efforts for 24 months to collect it. And there's a factual dispute that is currently being litigated in a Romanian court about whether this respondent used its best efforts to collect the money. And if this court doesn't stay the action, that issue will be decided in both courts. And then the question that was asked to counsel about what does this court do? That's the issue that we're trying to avoid.
Thank you. Thank you both.
Thank you.
Callahan versus the City of New York.
Roger Adler for the appellant. Can you hear me?
Yes.
Very good. May it please the court. The appellant, John Callahan, respectfully appeals from an order of Supreme Court, New York County, Judge Crane, which, while we awaited decision from the United States Supreme Court in the New York rifle and pistol versus Bruin case, is about to be handed down later this week.
Counsel, I'm glad you brought that up. Why shouldn't we hold our decision or any decision on this appeal in abeyance until that case is decided by the Supreme Court? The argument was in November. It'll be decided by the summer, and it might be dispositive of this case.
I absolutely agree with the court in terms of the husbanding of scarce judicial resources and to show respect to the trial level court, which would not have had the benefit of the case. And judges might believe somehow the judge did something wrong, but she didn't have the benefit of the New York rifle and pistol case. So I have no objection to the court holding the appeal in abeyance and subject to how the case comes down to make an appropriate ruling applying the law, but at the same time showing respect for stare decisis and the precedent of the United States Supreme Court. I agree. So let me just talk about 1 or 2 other issues that may be of some significance other than that, but I do concur with the court's suggestion as being a prudent use of scarce resources. The appellant was not found to be lacking in the character or the background. He had a permit. There was no allegation he breached any of its terms or conditions. Rather,
didn't he make certain misrepresentations in his renewal application?
No, what the license division said was, and their decision after appeal is found at page 20 of the record on appeal, was that they felt that he had not established an exposure to, and I'm quoting from the decision, extraordinary personal danger documented by proof of recurrent threats to life.
So let me stop you there, Counselor. It's pretty clear from the record that he's not carrying large sums of money, correct? And in fact, he says that these days less cash is being used. So the reason he needs the license is to protect his clients who may be carrying large sums of money. So my question is are you applying for the right type of permit here based on just the affirmative representations of your client?
I believe he is, because it's his job, it's his safety, his concern, and I want to draw a distinction.
But how is it his concern if he's not carrying the money?
because his personal safety is involved in terms of being in these neighborhoods after dark, particularly
But
at a
didn't he
time.
say,
sorry,
sorry,
what does that mean,
sorry to
Counsel?
interrupt
What do
you,
you
but
mean by
didn't he
that?
say that he was, sorry,
I'm sorry.
Didn't-
Go ahead. That was rhetorical.
didn't he say that in, I think, the second iteration of his explanation, that it was for to make his clients feel comfortable? They're the ones who are carrying whatever it is. So if he's doing that, isn't that the, essence of a carry guard license? He's guarding his clients and he's protecting them. I mean, he doesn't need to be there other
Well,
than that.
I think it's a hybrid situation, but the distinction I think that's important for the court, and how the court resolves it is obviously up to the court. But it draws a distinction between the qualifications of the licensee and the purpose of the license. And I just wanted to note that the Court of Appeals in People versus Hughes, I think in 22 New York 3rd at page 44 in 2013, indicated the nub of the test. And the nub of the test is allowing the license division to do what? To keep guns away from people who can't be trusted. So I'm drawing a distinction between the quality of the licensee and the purpose of the license. And my purpose in drawing that distinction is to respectfully submit that under the Second Amendment, the license division has no right, this is the appellant's position, has no right to second guess a licensee who has held the license, wasn't accused of violating the license in any way, shape, manner, or form, or engaging in any of the conduct in terms of lack of transparency.
But counsel, the license isn't also something that renews by itself in perpetuity. You have to continuously reapply for this license. And at that time, the Commission required the proof of the heightened risk of personal danger. Where was that risk?
No, I'm agreeing with you, but I'm saying that once the license has been issued, a licensee is entitled to greater due process than a mere applicant. That, I think, is the core. And I wanted to simply point out that were he accused of being less than candid, and I understand what Judge Mazzarelli was getting at, because I did read Tate versus O'Neill, a 2020 decision that Justice Mazzarelli was on the court, as well as the decision in Corbett versus the City of New York, where Justices Friedman and Justice Singe were on the court. And in that case, it was a failure to answer questions. So they didn't know whether Corbett was trustworthy or not. Here, Callahan was fully transparent. They simply were saying, we don't think you have enough of a need. And what separates, for those who are involved in the Second Amendment at this point in our history, is, does the government have the right to make that decision, or does the licensee have the right? And if he meets the criteria, simply put, it ought not be the business of the licensing agency to second guess, any more than to say you can't have a driver's license because you could take the subway. Where does that power come from? In this connection between this fight over administrative versus statutory law, let me simply indicate this. The denial was not based on a violation of the penal law or the administrative code. According to the police department, that denial was based solely upon a violation of rules which do not enjoy force of law and which were never adopted or enacted. You will not find any mention.
Thank you, counsel. Thank you. I'm going to move on, and you have some rebuttal. Respondent here.
Thank you, Your Honors. Lena Drucker on behalf of Licensing Division. So first of all, to be very clear, there were inaccuracies in his initial application. He said that he carried large sums of money. The department then came to him and said, which is clearly set out in its rules, if that's the case, please provide us with documentation. If you carry and deposit large sums of money, we need receipts. And he backpedaled there. He said, and admitted that he had made a misrepresentation. He said, actually, I don't carry large sums of money. That's my client's money. And he made a very clear representation in his second application. I've been doing this for years with no issue to date. Having my carry permit has helped me to increase my business dramatically. My clients have that added sense of security, knowing I am able to protect their property and monies at a higher level. That's a quote on page 2 of the record. So he made a clear application for a permit that is a carry guard permit, a permit seeking permission to protect other people's money and property. That was the basis of the denial, which is on page 20 of the record. Very clearly states, you have not shown proper cause. Proper cause
Counsel,
is, yes, Your Honor.
I'm just going to pose the same question in terms of the Supreme Court case that is currently pending decision. Should this court hold our decision on this case in abeyance and wait for that, or if not, why shouldn't we?
No, Your Honor, for a number of reasons. First of all, this is an Article 78 reviewing the license division's determination and an application.
But if the regs are struck down, and I don't know if they will be, if the regs are struck down, then really that's what your adversary is getting at. I mean, what's left at that point? I mean, wouldn't it be prudent to see what the U.S. Supreme Court does before we issue a decision?
Well, if the regs are struck down, presumably there will be a period of time. Last time the Supreme Court struck down a gun law, that in both the Chicago case and in the DC case, they were given 6 to 9 months. Yeah, in Heller and in McDonald, they were given, I think 90 days or 60 days or something like that, for the state to promulgate a whole new set of laws, at which point the city would then promulgate a whole new set of regulations. So we're talking.
But this case would then essentially be moot, right? Because there would be a new set of regulations, which we would be assessing the licensing application.
So Mr. Callahan would presumably have to wait, reapply, and then we'd have a whole new case. There has been a gun case before the Supreme Court every year for a number of years now.
Well, except
the suggestion is the court should just wait.
Counselor, this time it's New York's regs that are under attack.
No, that's not right, Your Honor.
They're not
the case that is currently before the court is NYSERPA versus Bruin. That case comes out of the Rockland County, I believe, or I'm sorry, it's an upstate case. It's not a New York City regulation at all. There's no challenge to the way that the city applies the rules. NYSERPA, 2 years before, in 2019, there was a city regulation. That case was dismissed by the Supreme Court as moot. So now the case that's challenging is only challenging the penal law, section 5.
So doesn't it involve the penal law provision that's involved in this case too?
Yes, so it does. So indirectly, yes, Your Honor. So that case is challenging.
I don't know why that's so indirect.
If the Supreme Court of the United States,
indirect.
If they strike down the licensing framework that the state has, then this framework goes with it.
Yeah, absolutely, Your Honor. If the court would want to wait, it could wait, and what would happen is that this whole case could become moot. If the state's laws are struck down, there'll be a whole new set of state regulations that would have to be state law passed, and then city regulations, and then a new application process. And that is certainly within the court's discretion to do. It just doesn't seem necessary because Mr. Callahan's application wasn't denied because he failed to demonstrate proper cause. He didn't even submit the paperwork. I mean, just that sort of at a pure regulations, sort of nitty-gritty administrative.
If the Supreme Court strikes down New York State's approach to this, how do you see your decision here surviving?
If the court strikes down the entire proper cause scheme.
Well, that's the issue that's before the Supreme Court now, proper cause.
Yeah, it depends so much on how the Supreme Court writes its ruling, and I can't read the tea leaves to tell you what iteration, how much will survive, and how that would all play out. What I can say is that if the court affirms the Second Circuit as the law currently stands, the proper cause standard has survived constitutional scrutiny in the Second Circuit, in the Court of Appeals, in this court, in the Second Department. There's no reason other than sort of trying to read the tea leaves for us to decide. There's a currently existing administrative scheme. Mr. Callahan has not satisfied that scheme, and so he is not able to have a permit to carry a concealed firearm for self-protection. If the law were to change, the entire application process, several years down the line, we might be facing a different set of rules, but that's not where we are right now. Where we are right now is Mr. Callahan backpedaled from the initial representations he made to the department. He couldn't satisfy the requirement for the permit he sought. He seemed to provide information that suggested there was another permit that he never applied for that he might qualify for. And so where we are right now is that the Supreme Court, which is the court, not the US Supreme Court here, the justice applied the law as it stands, looked at the administrative decision that was decided based on the law as it stands, all of which was correctly done all the way through.
Thank you.
Thank
Mr.
you.
Bennett?
Surely. Just briefly, number one, I will consent and I will bear the risk of loss whichever way the U.S. Supreme Court rules, because I agree with Justice Friedman. This is about the penal law. This is about the administrative code. The rules were written by bureaucrats in the license division. But Justice Crane ruled, and the decision is clear, she construed my client as seeking a privilege, a governmental privilege. She did not recognize it was a constitutional right. And that is a fundamental flaw. This is not some favor that somebody is asking for. This is a constitutionally guaranteed right. And the fact that she dismissed the case without a court appearance, without notice that the case was going to be dismissed, raises procedural questions. But I'm prepared to wait. And however the U.S. Supreme Court rules, I will then await this court's decision. But I have no opposition to waiting to see.
Thank you. Thank you both.
Have a good day.
You too. Bank of New York Mellon versus Cillian Ventures.
Good morning, Your Honors. Ken Warner.
And afternoon, as it would be.
Oh, you're right. I've been staring at my
It's a
screen
long
all
day,
night,
and
I
either
didn't realize the
either
day
way,
went
it's a
by.
long day. I understand.
Anyway, good afternoon. This is Ken Warner of Warner Partners for BlackRock and for other respondents, collectively the institutional investors. Your Honors, I'm pleased. I'm making this application now so I don't interrupt the flow of argument as it goes forward. But I'm pleased to introduce David Sheeran, partner in the Texas law firm of Gibbs & Bruns, who has been admitted pro hoc vice, and he is prepared to argue on behalf of respondent in this case with the court's permission.
Okay, thank you. I simply will say, since Justice Mazzarelli is on this panel, that we have thousands and thousands of very able lawyers in the New York bar, and well, you know, we like to see them too, but we will allow Mr. Sheeran to argue today. Thank you.
Thank you, Your Honor.
Thank you, Your Honor, and may it please the court. William Adams for the appellant Cillian. In this Article 77 proceeding, Supreme Court wrongly approved the trustee's use of the modified interest rates rather than the original interest rates in calculating the payments to the IO, which is the interest only.
Would you agree, Counselor, that there's an ambiguity in the various provisions in terms of what's the operative interest rate?
At the very least, Your Honor, we do think there is an ambiguity here. We agree.
Okay, so if there's an ambiguity, how didn't Supreme Court properly look to course of conduct, a long course of conduct, as to determining what the intent of the parties was? What was incorrect about that determination?
Sure, Your Honor. First, the court looked to course of conduct and course of performance only, and it did so in a pre-discovery posture. There was no discovery done here.
So let me stop you there for a second. Was there ever a request for discovery in the underlying papers?
Yes, Your Honor. There was a request before this case was transferred to Justice Cohen in the commercial division. It was handled by Justice Marcy Friedman. The request was made to her, and she denied the request without prejudice on the view that extrinsic evidence wasn't relevant until there had been a determination of ambiguity.
And then after the denial, was there a further request before Judge Cohen seeking discovery?
There was not, Your Honor, but that then proceeded to decision with the court then ruling first that it was apparently ruling that the trustee's interpretation was reasonable and then relying on the extrinsic evidence. There was no opportunity, of course, after that decision. That was the final decision that concluded the Article 77 proceeding. For us to make a renewed request for discovery. But in any event,
well, the implication is that you were satisfied to see it adjudicated without discovery if you didn't renew the request.
Oh, not at all, Your Honor. There was really no opportunity to make a further request in this context. Justice Friedman had decided the sequencing of the proceedings. The proceedings would be briefed on the papers. This is an Article 77 proceeding. It wouldn't have discovery. It wouldn't proceed to a plenary proceeding once we had this sort of gatekeeping issue as to ambiguity. And the court and ultimately Justice Cohen didn't resolve the proceeding without hearing for discovery. But if I may go back to Justice Singh's initial question, in addition to not having any discovery here, the course of performance evidence was considered without regard to the fact of there being credible sort of countervailing evidence that course of performance was based on a mistake. And if you look at nothing more, nothing more here, please look at the record, page 38, paragraph 48, where you don't have to take it from me. You can take it from the trustee itself, where the trustee is relying on a completely and opposite provision of the PSAs to support its use of the modified interest rates.
So your argument sort of sums up to the course of conduct was wrong, was inaccurate.
The course of conduct is mistaken, Your Honor. It's wrong. It's based on a mistaken, wrong. Either way, it's based upon the wrong provision. And as a matter of New York law, mistaken.
So the court should have looked behind the course of conduct and evaluated the course of conduct before considering it, is what you're saying.
Absolutely, Your Honor, as part of the full evaluation of the extrinsic evidence. Yes.
So we look at the extrinsic evidence and then we look at the extrinsic evidence supporting the extrinsic evidence, is what you're saying we should be doing.
Well, you have to know, Your Honor, what extrinsic evidence at its core is supposed to be probative of the party's intent. A mistake in course of performance, a course of performance that relies on a wrong contractual provision, is not probative of the party's intent as to the actual provision that's at issue.
All of the other holders were satisfied with what was going on for years.
We don't know that. We don't know that, Your Honor.
What do you mean we don't know that? Do we have any cases?
Well, no, we don't know because there wasn't any discovery to know about the other what the other holders. Certainly, no other holder brought a suit, but that doesn't mean that they either knew what was going on or had the economic sort of incentive to bring this action. If there was discovery, discovery would show that Cillian actually is a long-term investor in these certificates, raised this issue with the trustee in 2010 and 2011, but ultimately didn't bring litigation until it had the economic sort of incentive to do so once it acquired additional certificates in 2017. That's not in the record, but that's what we expect discovery will show, and that's why it was premature for Supreme Court to resolve this Article 77 proceeding without any discovery, without any an assessment of whether the course of performance evidence was actually probative of the party's intent. And
so when you say it's wrong, but one of the key terms of art that I used here is the term adjusted net mortgage rate. And that's defined as at any time the per annum rate equal to the mortgage rate minus 2 fixed fees not relevant. So this use of the at any time sort of cuts against your position that to go back to this original rate.
I think at most the use of any time, or there's also from time to time language, those temporal language at most injects an ambiguity here. Neither, and the Supreme Court certainly looked to those provisions, but in doing so, it ignored the commercial context.
How does it make it ambiguous? When you say you want to use the original rate, so there's some original fixed rate that's going to continue to be used, why are you talking about from time to time or at any time?
My adversary's position and Supreme Court's position was that the from time to time language is rendered superfluous by our interpretation, that it means nothing. But what the Supreme Court didn't consider is that these are template contracts for the Seawall securitization program. They have a standard set of definitions. In fact, if you look at the definitions here in the representative PSA, there are 18 definitions that are defined terms that are used nowhere else in the remainder of the agreement. And so the from time to time language here allows for the definition of the mortgage rate to accommodate trusts that have adjustable rate mortgages, not just those that have fixed rate mortgages. The parties opted not to have a bespoke definition of mortgage rate. And this evidence, we think there should be discovery to determine the party's intent in contracting and pursuing and in creating this term. And in fact, it's undisputed that there is one trust that the trustee selected for inclusion in these proceedings that does hold adjustable rate mortgages. And there are dozens of others and other trusts that are part of this same securitization program that has adjustable rate mortgages. And the term mortgage rate wouldn't make any sense and wouldn't work for those trusts without the temporal language. So we think our interpretation brings it all together and reflects the commercial context that has trusts that have adjustable rate mortgages, fixed rate mortgages, and some that have both.
And what you're proposing is to benefit the interest-only certificate holders at the expense of the principal and interest certificate holders. So after a 10-year practice, and in the face of this time-to-time language or at any time language which appears in the definitions and have application to the terms we're using, we should set that aside and say that now we go back to an original fixed rate.
Well, certainly the course of performance has been going on since for
10 years.
For some time now. I think the initial modifications were 2010, 2011. I think there might be a disputed issue as to whether they were really material until a few years later. But Cillian brought suit in 2019. But there's nothing inequitable or improper about interpreting the contract and discerning the party's intent. I mean, certainly there's a historical issue about how we, unwind and make up for the interest shortfalls.
In terms of the historical issue, and when you buy into these certificates, it's an investment and certainly very appropriate. But when you buy into it, you know that this is what you're buying into, don't you?
The parties are certainly sophisticated investors, and they can understand that the trusts here have been disproportionately affected by loan modifications than other trusts have. So they certainly knew that. But it's not publicly disclosed how the trustee is calculating and whether the trustee is using the modified rate or the original rate. So that's not something that was publicly known.
I don't want you to misunderstand that by asking this question, I mean in any way to be critical. I mean, they buy into this knowing that this is the way it's done, and they must be contemplating, to bring this lawsuit to undo it. And I think the number I saw was it's like $240 million at stake on this. So this is a strategic move to move into this, knowing that this is the way it's been done for 10 years or 9 years or 11 years. And we're going to look to change the way this has been done to the benefit of the interest-only certificate holders. That's the historical context of this. And again, I want to stress, in putting that out, I don't mean to be critical of it. It's certainly an appropriate thing for an investor to do.
I think that may be the historical context, and certainly, Your Honor, but it's important that at bottom here, we're looking at an interpretation of an agreement and in our view, correcting a mistake, a long-standing mistake that the trustee has done. I mean, trustees make mistakes all the time. I mean, Article 77, these proceedings are intended to address those. And in fact, the agreement here has a particular mechanism when there are interest shortfalls that allow for a sort of reallocation and a additional payment of interest. That's at R77 in the record, and it's called class unpaid interest amounts for class interest shortfalls. So there's a mechanism in the PSA for remedying exactly like this. And even if thinking about sort of, that's the historical issue. There's certainly no problem or sort of equitable issue or any sort of acquiescence or waiver or anything that Supreme Court was trying to get at with correcting this mistake on a going forward basis. So we think it's
Thank you. Let's hear from your the respondents here. For BlackRock, is that Mr. Sheehan?
Yes, Your Honor. May it please the court, for BlackRock and the 5 other institutional investors with substantial investments in these trusts, again, thank you so much for allowing me to appear here today. I'll focus on the contract terms, and Mr. Haupt, for petitioner BNY Mellon, will walk through the course of performance and extrinsic evidence issues. Your Honors, interest rate modifications are at the core of mortgage servicing. They're at the core of these trusts.
So you stand in opposition to what Mr. Adams is asking us to do.
Absolutely.
Yes. So, but I wanted to ask you is that there are other calculations that are made in the course of this pooling and service agreement and in this investment where the term mortgage rate is used. And in those situations, the Bank of New York Mellon does use the original rate. For instance, in calculating principal payments made on principal-only certificates. And on principal and interest certificates, even though the calculation uses an adjusted net mortgage rate, the Bank of New York Mellon also uses the original rate to calculate the allocable share for debt service reductions and Relief Act reductions. So the point of my question is that in other contexts, you do appear to do what Mr. Adams is asking for here.
As to the first of those, Your Honor, we respectfully disagree. The allocation of the principal-only certificates and the identification of the discount and non-discount loans, as explained by the court below, happened one time when the trusts were issued 15 years ago. And at that time, the initial interest rate was the only interest rate. So that was the interest rate used to make those categories. As to the allocable share, they are wrong. That is done on the basis of the loan's current rates. But Your Honor, the bigger picture here is that at the end of the day, what Cillian seeks here is a lifetime guarantee on interest rates that we know have been modified downward because we had a foreclosure crisis and because we had a financial crisis. They claim that guarantee, which as was noted, would amount to over $250 million, even though these modifications to the interest rates are the thing that avoids the worst case outcome for Cillian's certificates, which is a foreclosure. Cillian admits that if these loans go into foreclosure, its cash flows on a given loan go to zero. They aren't reduced. It's not a matter of getting a lot of interest or a little interest. They get zero. There have been thousands of these interest rate modifications, so much that they account for 40% of the loans in these trusts. There is a give and take between investors and borrowers here. It's in everyone's interest for interest rates to be reduced to continue the life of these loans and to maximize value for the trusts. And the court was correct to reject Cillian's claim of a lifetime guaranteed interest rate back in 2004 and 2005, a guarantee that no investor in these trusts has, Your Honors. And the court was correct to construe the 3 key terms to mandate the continued use of the dynamic method. We've talked about adjusted net mortgage rate. It contemplates the interest rate at any time, temporal. We've talked about mortgage rate, which is the annual rate of interest borne by a mortgage note from time to time. Again, temporal dynamic terms, whereas the interest rate, it's in the mortgage note, it's borne by or transmitted by, it can fluctuate. And when you look at the definition of mortgage note, it really removes any and all doubt. It says the mortgage note is the original executed note or other evidence of indebtedness, evidencing the indebtedness of a borrower under a mortgage loan. After a modification, that initial mortgage note does not evidence any indebtedness. If there was once a 10% interest rate owed that has been slashed to 5, The only indebtedness after modification is 5. And the trial court was right to note that following a modification, that initial mortgage note just doesn't evidence any obligation at all. And for that reason, there is no ambiguity in these contracts. They clearly require the dynamic method. And the court did not find an ambiguity. The court found that the language solely supported the dynamic method, and the court was quite clear about that. At 7, the language of the PSA supports BNYM's use of the dynamic approach. Decision at 19, other features of the trust confirm the changing nature of the mortgage rate.
But counsel, didn't the court also say, even assuming some ambiguity, so it suggests that there may be ambiguity, no?
What the court said is, in the alternative, that is, if someone else were to find an ambiguity, here's why I wouldn't be persuaded based on the best proffer of Cillian that I saw. And they did proffer, and you'll hear from Mr. Haupt, a variety of theories about what other trustees do, what other contracts say.
And thank you for that segue. Let's go to Mr. Haupt now.
Thank you, Your Honor. Christopher Haupt of Mayor Brown for the Bank of New York Mellon. This case is really uniquely well suited for resolution based on course of performance because we have not just a few.
So let me stop you there for 1 second, counsel. I want you to address your adversary's, well, 2 things I want you to address. One is your adversary's position that, in fact, course of conduct doesn't apply here because it's based on mistake. And second, at the very least, they should get discovery on course of conduct.
Sure. Maybe if I could start with the second one, I think that's more straightforward. They told Justice Cohen, not just we want discovery, they said, if you give us discovery, here are the 2 things that we're going to prove. One of them is mistake, which I'll get to, and that's wrong as a matter of law. And the other, they put in an expert report about what the other trustees do. They didn't need discovery. And on both of those points, he didn't say, well, sorry, you don't have admissible proof. He said, I see your evidence. I understand what you're trying to prove, and it's not persuasive. It's not going to move the needle. So we don't need to have, the trustee has a need to get instruction to make payments every month. This is not an academic exercise where we go turn over every rock. And so I think he recognized that discovery is not going to affect the outcome. Now, as to mistake, they're just wrong in asserting that what the trustee is subjectively thinking about the text of the contract is relevant when it performs. What the mistake cases say is one of 2 things. Some of them say that conduct that is objectively not reconcilable with any reasonable reading of the contract is irrelevant. That's the Chicago Railroad and Brainerd cases. And the other cases, like Justice McGuire's decision in Gulf Oil, are where a party tries to prove its own mistake to avoid being bound by the other side's conduct. So, for example, maybe an example will make it clearer. In Gulf Oil, the reinsurer said, the other party sent us checks and we cashed them, but that's not performance in the sense of agreeing with the computation because the other side represented to us that that was the correct amount. So we just processed them and we didn't understand what their conduct was until we figured it out later on. Or there's another case where a vendor sent invoices to the government paid them, but the government said, we didn't have conduct in agreeing with them, we just paid the invoices. There's not a single case that says that when a party actively performs, it's the one doing the calculation, that evidence is not relevant unless it's coupled with evidence about how the party was parsing the text at the time. The cases say the best evidence of intent is what the parties have done. It's their acts. It's what they did. It's not why they did it. And in any event, at the risk of getting a bit technical, they're just wrong about this mistake theory. One of the provisions that we cited in the petition governs an interest-only certificate at what's called the lower tier REMIC, which is a sort of tax structure within the trusts. The lower tier REMIC owns the loans and generates all the cash, and it issues bonds to higher tier REMICs, and then the master REMIC ultimately issues bonds to public investors. The provision that we cited governs the lower tier bond that corresponds to the bond that Cillian owns. And we think it's relevant. It's one of the provisions you should look at. even if they disagree with that, it's not a mistake. And it's certainly not evidence that the trustee was just flinging money out willy-nilly without, even looking at the right section of the contract. And it's only by sheer coincidence that we happen to, every single month for 278 trusts, land on what you would get by applying the dynamic method and using the modified interest rate. Unless the court has any further questions, I think I'm done. The decision below is, as Mr. Sheeran pointed out, is robust. He finds that the contract is clear, it supports what we're doing, and even if it doesn't, he looked ahead to the next step, which would be course of conduct evidence, and he was able to resolve the case so that we can continue making payments for the remaining life of these trusts.
Thank you. Mr. Adams?
Thank you, Your Honor. The court below never concluded that the trustee's interpretation was the only reasonable one, but to affirm, that's the conclusion that you would have, the determination that you'd have to make. And simply put, today, I haven't heard anything that suggests that the trustee's interpretation is the only reasonable one. At the most here, there's an ambiguity in the contract. On the very least, there's an ambiguity in the contract that prevented resolution of this as a matter.
How do you respond to your adversary who says, no mistake, look at the contract, our interpretation is reasonable, and so therefore course of conduct over these 10 years or so is the best evidence of the party's intent?
I'd say it's a factual issue as to whether that course of course of performance was a conscious, intentional decision by the trustee based upon the applicable.
But 10 years of issuing of cutting checks. I mean, wouldn't that suggest that that is a course of conduct? It
seems to be that is the trustee's course of performance here, but the discovery will show that Cillian raised this with them as early as 2010, 2011, and objected and tried to obtain more information about how they were calculating the pass-through rate. And the petition itself points to, and I didn't hear any dispute on this, does not point to the pass-through rate itself as being the applicable provision. It points to a separate tax calculation, which uses materially different terms, including interest accruals, which gives the trustee a lot more leeway to include modified loans. The definition of mortgage note means the original executed note or other evidence of indebtedness. That's a term of art which does not include a loan modification agreement. And certainly here, even if it did, it wasn't the original evidence of indebtedness, because a modification agreement can't be something that's first in time. So we have at the very least, there is a strong, plain textual argument that supports Cillian's interpretation, balanced against the course of performance evidence as to which there's a factual dispute as to whether it was based upon the correct.
How long did the course of conduct go on unchallenged by other interest-only certificate holders?
No other interest-only certificate, 6 years. I'm told 6 years. But I think you also, in the course of the commercial context here, Your Honor, is that some of these trusts, the difference between the modified rate and the original rate would only result in changes of hundreds or thousands of dollars, and so it wouldn't be in their economic interest to bring litigation. We brought litigation, certainly as soon after acquiring a more substantial share of the IOs.
But those two are sophisticated investment holders for the 6 years.
There are other holders who may not have had a financial or economic incentive to raise these issues, or they may not have exactly known what was going on. But this was going on for 6 years at most. And I'd also like to point the court to, in addition to the course of performance evidence, if discovery was permitted, there's significant evidence that other peer trustees were doing adopted the exact same position that Cillian has in covering 95% of comparable trusts. We have preliminary expert analysis. So that was something that additional extrinsic evidence should have been considered by Supreme Court, and we respectfully suggest that the case be remanded for full consideration of all extrinsic evidence. Thank you.
Thank you. Thank you all. Thank you. Lewis versus Flintock Construction.
May it please the court, F. Morton Chall for the appellant Lewis. It's our position that the July 27th ER record from St. Barnabas Hospital was mistakenly admitted into evidence.
Well, counsel, let's talk about that mistakenly admitted into evidence. This was these medical records were certified and entered into evidence by plaintiff's counsel, correct?
Right, but plaintiff made.
And then they were relied on specifically and referred to during the testimony by plaintiff's counsel, correct?
Parts of the record, correct, parts of it. But plaintiff's counsel maintained that this is not on the record because these documents were submitted into the record, off the record. And plaintiff maintained that they were all subject to redaction. And that proof of the fact
but counsel, that's not in the record. So how can we consider that, right?
I understand that. But,
so we're sort of stuck with what my colleague is suggesting. We have the records and evidence. They're used by different parties in different ways. Mid-trial, finally, there's an objection. Isn't it waived at that point?
Well, it wasn't moved at that point because there was still plenty of trial left to go. There were many witnesses who were being called. The point is, there was a contention. This was a contentious issue at the time of trial. It takes up several pages of transcript. Plaintiff's counsel said that this was subject to redaction. Defense counsel denied that. But as I pointed out in my brief, it's clear that the plaintiff was correct because the trial judge didn't say, oh, listen, these were all put in subject to redaction. The trial judge said, I'm admitting it because it's germane to treatment. And in fact, the trial judge did redact that part of the record which said that he fell on steps. He took a misstep yesterday. He said you can't refer to the word yesterday. From the fact that the trial judge himself said that, he ruled that, I am redacting part of that note.
He redacted the word yesterday. He ruled on the word yesterday.
Yes, he did.
Well,
right, he did rule on that
word.
Well, not only that, it's several pages of transcript. He also ruled on the admission of the rest of the note. He said he felt it was germane to treatment. I mean, if from the fact that he said that it was germane to treatment and that's why he's admitting it, proves that all these records were submitted subject to redaction.
But why does it prove that? Doesn't it sort of suggest that maybe mid-trial there was an objection, and at that point the court has to rule on the objection, and so the court ruled on the objection mid-trial or 4 days into the trial, I think.
No, because if the plaintiff himself had submitted these records into evidence and waived any problem with these records, then the trial judge should have said, listen, counsel for plaintiff, you're the one who put this into evidence. You can't now come and say that.
He didn't need to say it. He didn't need to say the obvious. There was no motion in limine. There was no request to redact ahead of time. The records were properly certified. The records were admitted by plaintiff. 4 days have passed. Now there's an objection. And by the way, the plaintiff has already relied on portions of that the record, and then finally there's an objection.
Right.
So the court ruled on that one objection is, and as my colleague said, only to the word yesterday.
Well, he did. I mean, I think, but it's our position.
Well, it certainly can be read to be only to the word yesterday.
Correct. He ruled that word should be redacted from the record. But that in itself proves that the plaintiff did not waive that these records were submitted subject to redaction. Because otherwise the court would not have ruled that way. The plaintiff himself put them in and said, all these records are okay, these are all in evidence, and nothing is subject to redaction, then the court would not have redacted that word. But I think this...
Do you have another argument? Any other issues?
Yeah, other issues. The second issue is, being that the court did redact the word yesterday, our position is that, notwithstanding the fact that the court clearly redacted the word yesterday and that this was hearsay, it did not belong in there. Defense counsel repeatedly hammered away at the yesterday in there.
And how many times did trial counsel object to the use of word yesterday?
Well, he objected it twice while Dr. Cohn was testifying.
But on summation is what you're talking about.
Right,
when
summation,
repeatedly
summation,
used,
he did not object.
No objection, no request for a curative instruction, no request for mistrial, none of that, right?
Correct. He did not object to it. He did object to it twice during examination, the direct examination of Dr. Cohen, the defense witness. He did not object to it during the 9 times it was mentioned in the summation
my
by
notes
defense
indicate,
counsel.
correct me if I'm wrong, that Dr. Cohen spontaneously at one time, at least once, used the word yesterday, correct?
He used it twice, and
But it was spontaneous. So in other words, defense counsel wasn't attempting to elicit information. This just came out of the doctor's mouth.
correct.
Okay. So then on those grounds, how wasn't there a waiver here?
Well, I mean, we're just saying we're not saying that there was a waiver of it, because we're asking the court, even though he did not object to it and he did not move for mistrial, we feel that this is a fundamental error and it's deprived the plaintiff of a fair trial. The word yesterday was critical to the case because it showed, I mean, it established in terms of the minds of the jury that the July 27th accident did not cause any problem, but rather was a problem that occurred from yesterday, July 26th, the day before.
Thank you.
Okay.
Thank you. We have your point.
Okay, thank you.
Respondent?
Yes, if it may please the court, David Klupfel for the defendant respondents, Flintlock Construction and Bass Associates. May I proceed, Your Honors?
Yes.
I'm impressed with the court's knowledge of the record. Appellant's present challenge on the basis that this entry was not germane to treatment was not made at trial, certainly not preserved for appeal, nor is their present application for a mistrial. As the court correctly pointed out, the plaintiff was the proponent of this evidence that he now challenges.
The court made a ruling as to yesterday. Was there any instruction to your witness, the doctor, not to use the word yesterday in accord with the judge's findings?
The application that plaintiff made was only to preclude any further reference to the word yesterday.
Right, and then there was reference. And then there was reference. Did anybody say to the witness, don't, answer the questions, but don't refer to yesterday?
I don't believe so, Your Honor. I don't believe so. That wasn't my
witness. So there was no effort to abide by the court's ruling?
I'm sure there was. We stayed away from it after. I stayed away from it.
So how was it used nine times then during summation?
I can't speak about my other counsel. I can't speak to that situation. But I don't believe it was used too often after the court's instruction. And by the way,
whether it was used once or 8 times,
redacted it. Excuse me, Your Honor?
I said if it was used once or 9 times, it doesn't really matter. The point is counsel wasn't following what the court had instructed. I mean, that's the point, correct?
Understood, Your Honor.
Anything else?
I would just like to say to the point where counsel claims that this was subject to redaction. When we first brought up the original entry was 3 days into the trial during our cross-examination of Dr. Newman, and plaintiff had every opportunity at that point to stand up and say, hold on, I want that redacted, and they never objected. They never objected whatsoever. They made the late application a day later, after and only after they put on their own doctors.
Thank you. Counsel for, J&R Glassworks.
May it please the court, Your Honor, I would agree with Mr. Klupfel's statements, and I just want to clarify the record. One, the record remained, the St. Barnabas record remains in the record unredacted because it never was redacted. There was no, if you could examine the entire record, and there's no mention by plaintiff's counsel about any type of redaction or subject to redaction. They put those records into evidence and they went in on consent, and then they were used by plaintiff's counsel in the direct examination of Dr. Newman. And in fact, they were read into the record by plaintiff's counsel about a history taken on July 30th, 2007. And then the next day, there was the objection about the entry made on July 27, 2007, which was the date of the accident, included the term yesterday. I also want to just remind the court that the record indicates that Judge Tapia said simply stay away from the word yesterday. He didn't redact a record. He didn't order preclusion. He made no such record.
Well, what does that mean? If you say stay away from the word yesterday, are you not saying don't repeat the word yesterday? Don't use it?
I think so, Your Honor, but in context, it was more dictum than a ruling, and as evidenced by the fact that the record was
There was
never
an objection. There was an objection to the use of the word, and related to the the records, and the judge made a ruling to stay away from the word yesterday. Don't refer to it. And then it was referred to however many times, certainly more than once, in summation, not to mention by the doctor on the stand. Is that not a clear violation of the judge's ruling?
No, Your Honor, because I'll respectfully submit that the record was in evidence and remained unredacted. When we got to summations, Your Honor.
No. But if the judge made a ruling, then it was for the attorneys to abide by that ruling, was it not?
But
you didn't have to abide by the judge's ruling.
Your Honor, again, I would suggest it was dictum, and notwithstanding that.
What do you mean dictum? I don't understand your use of that term. He said stay away from the word yesterday.
Yes, but this was after the record. The record had already been published to the jury, and during summation, that record was in evidence, unredacted, and there was no mention. There was no request, and in fact, Judge Tapia, in arguments leading up to summation, specifically addressed it and said it was fair game. In fact, he said the cat was out of the bag, quote unquote.
Dr. Newman testified without objection, did he not, that about yesterday?
Exactly. Yes, Your Honor. He testified about the history that was taken.
Dr. Newman was plaintiff's witness.
Yes.
Is asked about this on cross-examination. There's no objection, and he mentions the yesterday.
Yes, Your Honor. And Dr. Newman's record also contained the St. Barnabas record, and that record went into evidence unredacted on consent. Dr. Newman's chart.
Let's hear from plaintiff again.
Okay. First of all, at page 45, there's an accident, sorry. At page 45 of the record, I'm sorry, page 544 of the record, the plaintiff's counsel says, Judge, actually every single medical record was marked subject to redaction. So this was a point of contention. Notwithstanding that, what we are sure about is that the court did redact the word yesterday.
Well, it ends up, as my colleague clarified, that it was your witness who mentioned yesterday?
No, on cross-examination of Dr. Newman, the second witness. The second witness.
Dr. Newman, your...
Yeah, plaintiff's witness on cross-examination. Right.
Well, it doesn't matter whether the cross-examination or something else.
On cross-examination, defense counsel queried him based upon that entry in the record. That's what was brought up. And plaintiff counsel did not object to it at that time. But prior to cross-examination of Dr. Mandeldam, the next witness, he did object to it. I agree it was a belated objection. Nevertheless, there was plenty of time left to the trial. There were many more witnesses. There was plenty of time to give curative instructions. And the court, in fact, agreed with the plaintiff that it was not appropriate. And he agreed with that objection, and he granted that objection. And he told the defense counsel to stay away from it. And despite that fact, and defense counsel knew what they were doing in summation when they said this 9 times. They were hammering this into the brains of the jury.
But why not? I don't understand. You know, trials are dynamic, and you know, we've all been there. And there are times when I've objected when there's no objection rate. I've sustained objections.
Right.
Why not raise an objection when the court's already said stay away from it? And what is the court to do at that point? The court might decide, well, that's a strategic decision by the attorney.
He did object to it twice at page 595 and 656 when Dr. Cohen mentioned it, even if he mentioned it not being prompted by the defense counsel, but he did mention it. And the trial court admonished him to stay away from it.
No, I'm talking about the summations.
I agree with the summation.
When yesterday was used, why wasn't there an objection?
I can't say why the plaintiff's counsel did not object to it. I believe he was under the impression perhaps he had already objected it twice while Dr. Cohen was testifying. You don't have to keep on repeating your same objections. He stated his objection, and this was before the court. This objection was known to the court. I mean, the case law is clear. You don't have to repeat your objection every single time. The same objection over and over and over.
Thank you. Thank you all.
Thank you.
Thank you.
Cancel versus Global Fertility.
Yes, Your Honor. May it please the court, Norman Oates for the appellant. The question before the court is whether the firing of the plaintiff was motivated at least by an impermissible motive. And I think the record plainly shows that it was motivated by defendant Annie Lou's retaliation for the plaintiff protesting and complaining about the defendant's on-the-job racist comments.
Counsel, was there some sort of text message exchange between Ms. Lou and the plaintiff that would maybe lean towards that they had some kind of amicable, friendly, if not more, relationship?
No, absolutely. And I think this is a case of before and after. And the question is, what was the views of the defendant, Annie Lou, towards the plaintiff before she protested the racist comments? And what was her approach and attitude afterwards? So it's a before and after case.
I'm sorry, counsel, for interrupting, but am I correct that at the time when the money was turned, the loan and the gift, wasn't that after? We're talking about after events and not before?
No, that is not correct. The plaintiff testified that she made.
But in your complaint, didn't you allege that the racist comments were made in July? And doesn't the witness from HR, from defendant's HR service, I think it's given out to sort of like an independent contractors, the HR, doesn't that witness testify that there was a call made to her or there was a communication to her by the plaintiff that was in June or July? And it's only later that the plaintiff testifies that this happened in August?
In answer to two questions, the complaint does say, the verified complaint does say it happened at the end of July. At her deposition, she corrected that and said it happened at the end of August. And the plaintiff.
Wait, let me understand. Would you clarify then? Are you saying that your client is saying that the statements, the racist statements, occurred at the end of August?
At the end of August, that's correct. And the timing is that the defendant had returned from her trip overseas at the end of August. And that's when the statements were made. That's correct. In terms of what Judge Friedman is referring to,
Miss Scales, doesn't
yes,
Miss Scales
Ashley Scales,
who was placed in June or July?
Well, no, she does. No, that is not correct, Your Honor. There is no record at all of the content of that discussion. She said, I have an email.
There's no record. Doesn't she testify?
No.
Isn't she deposed?
She's deposed.
Miss Scales is deposed in her deposition.
Right.
She recalls it as having taken place in June or July.
No, if I may read from her testimony on page 568 of the record, she's asked about, she said, I received an email from the plaintiff about something to discuss diversity. And then she was asked, well, when in fact did you have this conversation with her about diversity? And this is now 2 years after the event. And she says she's not sure. She doesn't know, in fact, that the discussion actually occurred in June because she says in the record, she's asked about it. She says, I do not know. And then she goes on to say, what are you reading from? And she says, I'm reading from my stuff. And there's no reference in what I'm reading from to any discussion about diversity. It says the word.
What about at record page 561?
Yes.
I think where Scales testified that in June or July of 2017, that the plaintiff had voiced concerns regarding some discriminatory comments. What about that?
That's the same. It's all the same thing. It's all the same thing. But then she reads, she's then asked specifically, when did this happen? And she says, yes, I'm looking to see if I could find out about that. Like, what does the word other mean? Because there's no record of this conversation. But again, the date of the email, also the entry, that might have been when we had that very sensitive conversation. So this is all built on someone who has no record of when it was, and it might have been then, which simply contradicts the plaintiff's testimony that this actually happened at the end of August.
Which coincides with the plaintiff's verified complaint.
Excuse me?
Which coincides with the plaintiff's verified complaint that it was July.
No. Ashley Scales is saying it happened in June. The plaintiff is saying it happened at the end of July in the complaint.
As between whether it's June, July, or August, and of course, whether it's July or August is significant. If it's June, doesn't really matter.
Right.
But what Ms. Scales' testimony is more nearly consistent with what the original verified complaint said.
Well, it's a month and a half before that. And I agree, I'm not
It's not August.
It's not August, but it's not July, it's June, okay? And secondly, one of the questions here is, when did she make the statement? When did Annie Lou, in fact, return? And remember what the correction was. The testimony of the verified complaint was, I made the complaint when Annie Lou returned from her trip overseas at the end of August.
When was the $8,000 loan made?
The $8,000 loan was made July 31st.
And when was the
2017.
And when was the $1,000 gift given?
September 1st of the same year, 2017. And then 2 weeks after that $1,000 gift, 6 weeks after the $8,000 loan, Annie Lou gets on the telephone and calls Ashley Scales and says, I've decided to fire. I've decided to fire her. And that's the whole point. There's nothing that happened before these events, before the complaint, in any way that led to any suggestion of being fired. She doesn't and that's why I said earlier it's a before and after question. That's why the date is important. And remember what the plaintiff said. The plaintiff said, without prodding, when they're reading the complaint at her deposition, she says, no, August or end of July is wrong because Annie Lou came back at the end of August. So the end of July is not correct. The plaintiff.
So it's the fact that she returned from her China trip that prompted her to recall it was at that point that those comments were made, after the return from China.
That is correct, because it's all related, because when she came back, one of the things she said to the plaintiff is, China doesn't like the fact that you're hiring so many black people. And that was the whole thing. And all of that related to the investor in China, who's the 70% investor, apparently had looked online at the photograph of the staff and didn't approve of the fact that there were several people who were not white or Oriental or were black. And the critical point is, Your Honor, is that although the defendant says this is a big change, it made a big difference, in the lower court and before this court, there's absolutely no evidence that the defendant has put in that Annie Lou did not return at the end of August. In other words, at the deposition, she corrected it. The defendant had an opportunity to say this correction to the end of August is wrong. All Annie Lou had to do was put into evidence on the motion for summary judgment, her passport, even an affidavit. There's absolutely no evidence that this was done in any improper way as opposed to correction. And what they're asking you to do is to dismiss the case, even though there's no evidence at the end of August is the correct date.
Thank you. Let's hear from opposing counsel.
Counsel, they're not asking, what's at issue is whether to restore the retaliation cause of action. The case is.
But they're asking the court to
dismiss. There is a surviving cause of action here, no matter what happens.
That is correct, but they're asking the court to uphold the dismissal of that cause of action, although there's absolutely no evidence that the statement she made that was at the end of August is incorrect.
We understand. You don't want the retaliation claim to be dismissed.
Correct.
Thank you. Let's get to opposing counsel now.
Thank you, Your Honors. Joseph Tripodi on behalf of respondents. Just to clarify the record.
Let me just ask this question, and then the dispute about the dates, July, August, the plaintiff indicating that what prompted her recollection was this return from the trip to China, which happened in August, and other witnesses testing otherwise. Why isn't that a question of fact that allows for this motion for summary judgment to be denied?
Because she has created the conflict by her conflicting testimony, Your Honor. The complaint very clearly states that Annie Lou came back in July and the racist incidents occurred in July. She then, after we served the WeChat exchange where a defendant Lou committed, in addition to saying very nice things about Ms. Cancel, committed to paying $1,000 for a child, gifting her personally not through the
Yeah,
company.
but the plaintiff doesn't have these definitive documents. She's going by what she remembers. And she says, oh, that the return trip, that's when it happened. She doesn't have presumably the tickets or the passport or anything else to show when, her boss returned. So, and this didn't happen the very next day. So, there's some time that's passed. She said, oh, it happened in June or whenever it was, July. And then once she heard the date that she returned, she said, oh, it's August. Why isn't that something that the jury should decide? Why is that a basis?
That's not accurate. She didn't hear the date. What prompted her?
Not the date, the return trip.
Well, what prompted, in her verified complaint, she said the return date was in July. After we served the WeChat messages in discovery 30 days before her deposition, then at her deposition, these remarks were made at the end of August. Okay, but I would say this, and I want to clarify the record.
When you say these remarks, you're talking about the return trip and when that occurred.
No, I'm talking about the remarks, the alleged racist statements. And okay. The allegations are horrible statements. She testified, Ms. Cancel testified, that there were two separate statements made on the same day. The one, let's call it the morning, was about having too many Black people in the office, allegedly. And then in the afternoon, there was a statement after Ms. Cancel complained to Ms. Liu and then called Ashley Scales that same day. Later that day, Ms. Liu allegedly said that there was something about skin color and not minding lighter skinned Black people, something that allegedly, that's the allegation. Now, Ms. Cancel very clearly stated that occurred on the same day. According to Ms. Scales, she had, during her deposition, I was there, she was looking at her Salesforce entry on her laptop. She said she had an entry on June 22nd of 2017, where there was a webinar on diversity that Ms. Cancel had ordered, and that was established. That was June 22nd. She testified her notes related to a comment about having too many Black people. That corroborates, that's June 22nd.
Well, that goes to my point, question. That goes to my point, counsel. Counsel, excuse me, I'm sorry, but that goes to the point. You have now a third factor, this Scales testimony of a June date. Why again isn't this enough to create a question of fact?
Because she is creating, the only question of fact is created by Ms. Cancel's conflicting testimony. She's creating a issue of fact.
Counselor, hold on a second.
There's no other evidence to support her position.
Excuse me, Counselor, this is Judge Singh. So the issue is, when your client came back from China, what did you put in the record with respect to that issue?
We didn't put anything in the record, Your Honor, because frankly, a conflicting affidavit would have been a basis for
strategic reasons, obviously, right? For strategic reasons, because couldn't I infer from that the reason you didn't put it in is that the plaintiff is recollecting accurately as to when that occurred, but once you give the date of the trip, that issue will be resolved, and that's not something you want to resolve because you would rather focus on the inconsistencies on plaintiff's testimony, correct?
Your Honor, hypothetically, if we were to submit an affidavit that conflicted, that established that she came back in July, then the first thing counsel would say is issue of fact.
Counsel, it wouldn't have to be an affidavit. I mean, you could submit documentary evidence of when the trip to China take place, and it seems to emerge that if she returned from China at the end of August, then your position is significantly weaker in this motion. So if you would have documentary evidence, I mean, I can think of all sorts of ways which you can establish whether a boarding pass, a redacted piece of a passport, a visa. There are various ways in which you could have not just put in an affidavit, but established with documents when the trip to China took place.
I understand that, Your Honor, but all that would have done was created a conflicting issue of fact when we already have definitive testimony from Ms. Scales concerning when these complaints were made. Before June 22nd was the first one. As to the receptionist, which is
but Counselor, to accept that point would mean that I would have to weigh essentially accept that when that occurred, as opposed to the plaintiff saying, no, that's a mistake. It occurred after return from the trip. And I don't think that I am going to be, as an appellate judge, getting involved in weighing testimony of different witnesses.
Again, respectfully, Your Honor, the first department, when testimony changes, in opposition to a motion for summary judgment, when a party submits an affidavit in opposition to a motion that's inconsistent with his or her deposition testimony, the first department disregards that.
But correct me if I'm wrong. Wasn't the change made in the deposition here? So it's not on all fours.
It's not. Absolutely, it's not. But the policy and the theory and the underlying intent of that is the same. You have a witness changing her testimony to fit facts, and doing so in response to, and there was a triggering event. In 5 weeks before a deposition, we served the WeChat messages, which blew up and eviscerated her entire retaliation case. And all she has to support her testimony is just a change in testimony. That's it. She didn't present anything to support that August date, but we have testimony from Ashley Scales, from an independent, neutral third party who was looking at her business records and confirmed that the first one was the first incident that she was made aware of was before June 22nd. And the second one, with regard to the receptionist, she said that she had a note and an email on June 28th. This is all right, approximately in July, consistent with the plaintiff's verified complaint.
Thank you. We have your point. Mr. Holt?
Yes, if I just may briefly, there's absolutely no record that Ashley Scales has that in any way expresses the content of any discussion in June, July, August, or September. The only thing she remembers when questioned at her deposition is, yes, I do remember this comment about you're hiring too many blacks and things like that. There's no record of that. That's her recollection. Secondly, it is absolutely not true that Ashley Scales has a computer record saying we discussed too many blacks or we discussed LaShonda Mickens being, replaced by a pretty blonde. There's no such record. It simply is not true that, in fact, Ashley Scales has records of any of the content of her conversations. She has an email saying, I want to discuss diversity, and Ashley Scales has no recollection of whether or not she actually discussed it then. All she can say is at some time back 2 years ago, we did discuss this, and I do remember this comment about too many blacks being hired.
Thank you. Thank you both.
Thank you very much, Your Honors.
Butler versus City of New York.
May it please the court, Zach Shapiro for appellant respondent, the City of New York, and respondent Stephen O'Hagan. There are two reasons why Supreme Court should have dismissed Butler's false imprisonment claim against the city, just as they correctly dismissed other claims. First, Butler abandoned that claim by not opposing dismissal of that or any other claim against the city. Indeed, on appeal, he did not even file a respondent's brief. Second, the claim is time barred. Butler failed to bring that claim within 1 year and 90 days of its accrual when he was released on his own recognizance following his arraignment. And in relying on a later date, Supreme Court relied on a date that Butler had never argued for and that the city had no opportunity to respond to, and that fails on the merits. The case law establishes that a false imprisonment claim accrues upon an initial post-arrest release without regard to any subsequent incarceration. And that rule also makes sense for the multiple doctrinal reasons outlined in our brief.
So there's no question that he was falsely imprisoned. You're just saying that he run out of time to bring the claim.
That's our argument, is that the claim is time barred. We didn't get into the merits of it.
If you don't have anything else, do you have something else? You only
know
have
that if there are no other questions.
Any questions? Okay. Thank you.
Thank you, Your Honor.
Yours is the last case of the day. Court is adjourned. Thank you.